Good morning, all. This trial is in the matter of CFI 091-2024 and CFI 068-2024 and is being held by way of video conferencing before His Excellency Justice Michael Black, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Towers and Hamlins. Lead counsel is Mr. Matthew Watson. The defendant is represented by Vincent Masons. Lead counsel is Mr. Lawrence Page. Thank you.
Mr. Watson.
Thank you, Your Honour. What I propose to do in closing is to follow broadly the structure that I followed in my opening, which is to deal with the loan claim first and then the JV claim, and within the loan claim to deal first with the obligation to lend, and then the issues that arise depending on how Your Honour decides that issue, and then to deal with the JV claim and to deal firstly with the termination issue, and then the question of any relief if you find that the contract wasn't validly terminated, and finally to deal with the counterclaim. So diving right in with the loan claim and the obligation to lend. The issue is, of course, whether KGN can show that clause 2b was either breached in the sense that there was an obligation to lend and that was not performed, or that clause 2b was waived. There's a question about whether a Braganza duty is owed at all, and I don't resolve from that position, but in my submission, Your Honour doesn't need to decide that question, because even if there was a duty, KJN has not shown that it was breached. And so I'm going to address that question first and then say a few things about whether the duty arises, and then address the waiver issue. Probably the appropriate place to start is what is the standard required of a decision maker under a Braganza duty? And Your Honour should certainly stop me if at any point I'm teaching you to suck eggs. But I thought we'd start with Braganza itself, which Your Honour will find in the supplementary bundle at page 573 is the relevant starting point. If we could zoom into paragraph 18, this is the judgment of Lady Hale. She starts at the top of paragraph 18, saying contractual terms in which one party to the contract is given the power to exercise a discretion or to form an opinion as to relevant facts are extremely common, and ends that paragraph by saying the courts have sought to ensure that such contractual powers are not abused, done so by implying a term as to the manner in which such powers may be exercised, a term which may vary according to the terms of the contract and the context in which the decision maker is given. Paragraph 19, a very important paragraph, Your Honour. There's an obvious parallel, she says, between cases where a contract assigns a decision-making function and cases where a statute assigns a decision-making function to a public authority. In neither case is the court the primary decision maker. The primary decision maker is the contracting party. It is right, therefore, that the standard of review generally adopted by the courts to the decisions of a contracting party should be no more demanding than the standard of review adopted in judicial review. So Your Honour is not asking, is this a reasonable decision? Or is this the decision that I would have made if I was Contessa? Your Honour is concerned in a sort of quasi-public law sense with the quality of the decision making. And I'm just going to flesh a little bit of that out for Your Honour. There's a quote in the middle of paragraph 20. This is just going to show you a little bit about how the thinking on this has evolved. This is a quote from Lord Justice Leggett, as he then was in Abu Dhabi National. Actually, I think that's Leggett Senior. In my judgment, the authorities show not only must the discretion be exercised honestly and in good faith, but having regard to the provisions of the contract by which it is conferred, it must not be exercised arbitrarily, capriciously, or unreasonably. And then if one goes over the page, you can see at little b, essentially what there was in the authorities was a discussion about what does unreasonable mean in this context. And it didn't mean, and you get it then, the answer from Lord Justice Ricks and Sossamer, and that quotation that's at D, E, and F. I won't read it to you, but you can read it in its own time. What reasonableness in this concept didn't mean was an objective standard of reasonableness, like a duty to take care, or where the court is fixing a reasonable price. What matters is reasonableness in a Wednesbury sense, and you can see it little c. Unreasonableness is now abandoned as a term, and what is generally used is irrationality. You can see that it substitutes the more modern term irrationality for unreasonableness. That's at C. And then at paragraph 23, Lady Hale cites the judgment of Lord Sumption in Hayes and Willoughby about what rationality actually means. It says rationality is not the same as reasonableness. Reasonableness is an external objective standard applied to the outcome of a person's thoughts or intentions. A test of rationality, by comparison, applies a minimum objective standard to the relevant person's mental processes. It imports a requirement of good faith, a requirement that there should be some logical connection between the evidence and the ostensible reasons for the decision. That's what it means to make a rational decision. So to give Your Honour an example in the context of this case, if Contessa had said, this Admiral report is unsatisfactory because it's in a Times New Roman font, and I don't like Times New Roman, that would be a classic irrational decision because the reason has no logical connection with the purpose for which the decision's got to be made. Similarly, if Contessa said, well, this report's unsatisfactory because I don't like people called Enzo, that would be a classic irrational decision. So what Your Honour's looking for is, in the decision making, is there some logical connection between the reasons for the decision and the discretion that's been given to the party? And if we go over the page to 576 and focus in on paragraph 30, the question that was being actually posed here in Braganza is addressed at paragraph 30 is whether, where you're dealing with a term, it's the full public law test of Wednesbury unreasonableness, which is the decision's got to be rational, i.e. you've got to take into account relevant things and not take into account irrelevant things, and also a decision has got to be one that no reasonable decision maker could make. That's the other limb if you're going to challenge these sorts of tests. And at the end of paragraph 30, you can see that Lady Hale says that she would include both limbs of the Wednesbury formulation in the rationality test. So a decision is irrational if irrelevant considerations are taken into account, or if the decision is so unreasonable that no reasonable decision maker could have come to it. One last paragraph from the authorities, which is just over the page on 577 at 32. This is just an important bit of context for Your Honour. She says it's unnecessary to reach a final conclusion on the precise extent to which an implied contractual term may differ from the principles applicable to judicial review, given that the question may arise in many different contractual contexts. It may be that no precise answer can be given. The particular context of this case is an employment contract, which, as Lord Hodge explains, is of a different character from an ordinary commercial contract. Any decision-making function entrusted to the employer has to be exercised in accordance with the implied obligation of trust and confidence. And this must be borne in mind in considering how the contractual decision maker should approach the question. And then she goes on to actually address the facts of that case. In that case, an employer had to decide whether an employee had committed suicide, because if the employee had committed suicide, then the company was obliged to pay some money, and the employer had to make that decision. So it's quite a different case, but the point, for your honour, is that the standard of review is to some extent dependent upon the contractual context. And here you've not got, say, an employment relationship, you've got two sophisticated commercial parties. And in my submission, it's a high bar to say that a commercial decision taken by one is one that no reasonable, in this case, lender could take. But I'll just pause here to deal with a short point. It's because this is the test that KJM took a new point in its skeleton to say that satisfactory refers only to the quality of the report and not the quality of the yacht. And the reason for doing that, the tactical reason for doing that, is to try to make all the issues about the quality of the yacht an irrelevant consideration. Your Honour indicated that he didn't think there was much force in this point. There isn't any, and I'll address it very briefly. Satisfactory in clause 2b obviously pertains to the condition of the yacht. Contessa was only interested in a survey to discover the condition of the yacht. That's the whole purpose of it. On KJM's construction, that satisfactory only refers to the quality of the report, Contessa could have received a report that's 1,000 pages long, with every rivet carefully inspected, but the conclusion is the boat has a huge hole in its hull, and still been obliged to lend. That's the logical consequence of that construction, is that you can get an absolutely perfect report, but the boat is in a terrible condition, not seaworthy, potentially even beyond economic repair. Contessa is obliged to lend. That can't be right. And there's also an important part of the background factual matrix, and I'll just take you to two emails, which I don't think Your Honour has yet seen. In the core bundle, starts at page 1890. This is just before the loan agreement was signed. I see there's an email from Casey Flipman to Mohammed Al-Jazmi, and they're talking about the terms. And the original proposal, as you can see from the bottom, is the balance will be paid within 5 business days upon receipt of the written notice of acceptance of the vessel. So the original proposal was KJM will accept the vessel from the shipyard and then Contessa will pay. And at 1189, sorry, that I'm going too quickly. 1889. And if we could just scroll down, we see the response to that email from Mr. Al-Jazmi on the 30th of May, and he proposes something different, balance to be paid within 5 days of receipt of satisfactory report from appointed surveyor. This is in lieu of the factory will only allow us to accept the vessel only once complete payment is done. So it was known to both parties prior to contracting that the factory would only release the vessel finally once it had received that final payment. And in my submission, that part of the background factual matrix is very important when it comes to construing clause 2b. As everyone understood, that final payment was to be made once the vessel was in a condition where it could be accepted. So if there were any issues with the boat, They need to be sorted out before you get payment. And so that explains, Your Honour, what clause 2b is actually about. And it's about two things. Firstly, there has to be a survey, so Contessa is not obliged to rely on the shipyard's assertion or KJM's assertion. It relies on the assessment of an independent professional, and the survey has to be satisfactory. In other words, the boat has to be in a condition where it could be accepted from the shipyard. Essentially, it's finished. So that's the contractual standard, the meaning of satisfactory. I'm going to move to address what is, in my submission, the central factual issue for Your Honour, which is when the Admiral...
Sorry, you said two things. So the first is there must be a survey.
And the second is that the survey has to be satisfactory.
Okay, so that's the second.
Namely, the boat has to be in a condition where it could be accepted.
Okay.
So moving on to the question of delivery of the Admiral report. As I say, this is the central factual issue for Your Honour. And in my submission, the evidence overwhelmingly suggests that it was sent for the first time by email on the 11th of July 2024. And that's the email, we don't need to go to it, at page 1287. The burden is on KJM because it asserts that the condition was fulfilled, and it asserts that the report was sent earlier than that, and it has not discharged that burden. And in my submission, there are 5 reasons why Your Honour can be confident that it was not sent until the 11th of July. The first is the failure of Mr. Al-Jazmi to give any real evidence on this issue until yesterday. The first time anyone had suggested that he personally had handed over the document was in his oral testimony. It was in response to Your Honour's question, and you'll see it at day 3, page 17, lines 12 to 17. We don't need to go there, thank you, Plato. I'll just read the transcript, read the reference into the transcript. Now, Mr. Al-Jazmi even said that Parush Hyderabad Walla was there. But Parush Hyderabad Walla never said he was there. That account that Your Honour was given, that there was a meeting, Parush was there, Al-Jazmi handed it over, it was at the KJM offices. It was not in the defence. The relevant paragraph is paragraph 12 of the defence, which was at page 20. That account was not in the RFI response, which is at page 38 of the bundle. And importantly, it was not in Mr. Al-Jazmi's witness statement. That's page 95 of the bundle, paragraph 40. His evidence was just that KJM shared the report at some unknown time and in some unknown way. If what Mr. Al-Jazmi was saying was true, it is frankly incredible that he was unable to give an account any earlier than his oral testimony yesterday. He would surely have remembered, and he even accepted in his evidence that he had put everything important that he remembered into his witness statement. That was at day 3, page 23, lines 3 to 7. But on this issue, his witness statement was bare. and he had no real explanation for his failure to give an account. I pressed him on it. That's at day 3, page 25, starting at lines 8. But he didn't have an answer. And even if for some reason he didn't have it in his first witness statement, he should have been prompted after seeing Mr. Ivankovic's witness statement, because Mr. Al-Jazmi had a second chance to write a responsive witness statement. And he says he read Mr. Ivankovic's witness statement, and he responds on a whole series of peripheral issues, but not on this central question. He had no explanation for why he wasn't prompted after reading Mr. Ivankovic's statement. That's at day 3, page 33 to 36. His only real explanation for why none of this was covered is that this is the first time I appear in court. Now, Your Honour, that sort of explanation might just wash if Mr. Al-Jazmi had been instructing local lawyers who are unfamiliar with DIFC or common law procedure. But Pince and Masons are one of the jurisdiction's preeminent litigation firms, if I may say so. One obviously cannot know what went on behind the veil of privilege between the lawyer and the client. But surely Pince and Masons must have been desperate for Mr. Al-Jazmi to explain himself, because this is the central factual issue. But they got nothing until yesterday. And it seemed, I think, that Mr. Al-Jazmi's account was news even to my learned friend, because this account, that there was a meeting at which Parouche was there, and it was in the offices, and it was in July, and the report was handed over, was not in the skeleton argument. The explanation, for instance, that the reason why there's no email is because Mr. Ivankovic had said, oh, don't send any emails to my lawyers. That was the story that was given at day 3, page 17, line 6. That wasn't put to Mr. Ivankovic. Indeed, my learned friend wasn't even able to put any of the specifics. The way it was put to Mr. Ivankovic was that the report was handed to you in July 2023, or at the very latest by September. That was day 2, page 81, line 1. Now, if Mr. Al-Jazmi had been giving a consistent account from the beginning, my learned friend would have very properly been able to put that account to Mr. Ivankovic, but he didn't. And the reason he didn't was because he couldn't. And the reason he couldn't was because we only got that story for the first time yesterday. So that's the first reason, Mr. Al-Jazmi's inability to explain how the report came to Mr. Ivankovic until yesterday. The second reason is the inability of KJN to tell a consistent story. If Your Honour will recall, the defence said that the report was, quote, sent, not hand-delivered, it was sent. Then the RFI said that it was, response, said it was hand-delivered in July 2023 and provided in February 2024. And then Mr. Al-Jazmi, in the witness box, said that that was wrong because he said it was the corrective actions report that was provided in February 2024. That's day 3, page 20, line 6. So in the course of his evidence, Mr. Al-Jazmi was saying the RFI response was wrong. If Your Honour will recall, the expert had been told by someone that it had been handed on the 27th of September 2023. You know, that's a very specific fact to have been told, not it was sent between July and September, or it was sent in September. The expert had been told it was handed on the 27th of September. But no one seemed to think that was correct. And Mr. Al-Jazmi's witness statement didn't say it was hand-delivered, and he didn't say he'd done it personally. He just said it had been provided. So KJN has been unable to tell a consistent story. The third reason why Your Honour can be confident, is that by contrast, Contessa's position has been consistent throughout, from the very beginning of this litigation, in the pleadings, in the witness statements, and in Mr. Ivankovich's oral testimony, that the first time this report was seen was in July 2024. And the relevant part of the oral testimony is day 2 at page 80. And that's consistent, of course, with the contemporary documentation. Your Honour might remember, we could quickly turn it up, page 1302. This is the email. If we just scroll up a little bit to orient ourselves with the date. On the 23rd of July 2024 from Casey Flitman, where she explains Contessa's position on the 3 documents that had been received on the 11th of July 2024. She says these 3 documents are not satisfactory. She deals with the letter from Sino Eagle and says, well, this doesn't really tell us anything. She deals with the corrective actions report, and she says there are just pictures. What's going on? And then in relation to the Admiral report, note from Casey, the survey is more than a, so if we just scroll down on the screen, please. Thank you. Note from Casey, the survey is more than a year old, and there were repairs and improvements made in February 2024. Is there an updated survey? So the first thing that Contessa says about this survey when it's received in July 2024 is, well, this is a year out of date. Have you got a more recent? What must have occurred behind the scenes for KJM's case to be true? Moore & Co., having received this survey in July 2024, show it to Mr. Ivankovich, and Mr. Ivankovich lies to them, and he says, I've never seen this before. And so Casey sends that email saying this is a year old. Far more likely is that Mr. Ivankovich said, well, I've not seen this before. And the response that then goes back to KJM is, well, this is a year out of date. The fourth reason is the inherent improbability of this report being hand-delivered as the only method of its transmission. All the other important documents in this case passed between the parties electronically. Just 2 examples. I'll read the references into the transcript. The loan agreement sent by email, that's page 1893. And Admiral Marine's original quote sent by email 1909. But Your Honour only needs to just flick through the bundle. And every other document is an email attaching a purchase order or a letter or something. Because that's how business is done in the modern age. So Your Honour has to ask yourself, what is the inherent probability that the crucial document that triggers, arguably, the obligation to pay is provided only by hand in a meeting? Your Honour heard Mr. Ivankovich's evidence that he would have asked, if it had been given to him by hand, he would have asked that it be sent to his lawyers by email. And he gave that account in his witness statement as well. That's why, when he was coming up with his story, Mr. Al-Jasmine had to indent this conspiracy between him and Mr. Ivankovich of not sending it to the lawyers. And the fifth and final reason why Your Honour can be confident this document was not sent until July 2024 is the absence of any documentary trace of the Admiral report having been received before then. Even if it had only been provided by hand in July 2023, there would surely be some trace of it in the documents. At the very least, it would be discussed. And I'll just give you something to contrast it with. If Your Honour, we don't need to go there now, but goes back and has a look at pages 1075 and 1102. Those are the exchanges in relation to the Sunseeker between the surveyor and Parouche and Moore & Co. and Ollie Hand, discussing all the snagging in relation to the Sunseeker. Now, those are just two emails. The idea that if the Admiral report had been sent, had been provided by hand, that there wouldn't be any emails of that kind, no record of any discussion about the snags, what was going to be done. Even if Your Honour takes the view that they're just minor snags, there would surely be some record of some discussion, but there isn't.
Can we just wind back slightly? Have you finished your 5 reasons?
Yes, Your Honour.
Can we just wind back slightly? Because as I understood the thrust of Mr. Ivankovich's evidence, he was not persuaded that there was an actual contract of sale for this vessel at all.
Well, I think that is, to be fair to Mr. Ivankovich, a view that he was coming to. I don't think he was ever specifically asked when he came to that view, but Your Honour might remember that I took Mr. Al-Jazmi to the exchange in April, where the lawyers start asking for copies of the purchase agreement, and the response that comes back from Mr. Al-Jazmi is, well, all this is confidential, you've got to come to my offices, I'm not going to let you see it. And even now, we don't have a copy of the purchase agreement. We asked for it in disclosure. I might just show Your Honour the response that was received, because that's it is. We'll just deal with this point quickly now. The best way to get into this is at page 438 of the bundle. This was an email from my solicitors to Pincer Masons, and they say request number 1 of the claimant's request to produce sought a copy of the contract between Sino Eagle and the defendant for purchase of the Aquila, and there was no objection to production. And we said we note the document was missing from the documents disclosed. Document number 1, which is provided by the defendant, contained an email from Wasim Kadra to Ivan Emu. That email refers to a signed addendum. Please provide us with a copy of the signed addendum along with the contract between Sino Eagle and the defendant for the production for the purchase of the yacht. Now, Your Honour might remember I opened Mr. Al-Jazmi's cross-examination with that email. It's at page 925 of the bundle. I need to go there. So this was and Your Honour saw there was a very brief exchange, payment of $1 million deposit. No terms, nothing about price, nothing about payment schedules, nothing about delivery. It was very sketchy.
So page 925.
925.
Where am I looking? Thank you for sending signed document, proof of payment transfer.
Yes, and if Your Honour scrolls down to 96, you get the original email from KJM.
So we are pleased. Well, yes, we are pleased to enclose the signed addendum. So what is the signed addendum?
Well, Mr. Al-Jazmi's evidence was that it was nothing to do with this at all. It was all to do with something.
Oh yes, he said about Egypt.
Egypt. And can I just show Your Honour, just to complete the inter partes correspondence?
So,
but those two emails that you've just looked at are the sum total of the disclosure on the question, can we see the contract? Yeah. So that is it.
Now, Mr. Hyderabad-Wala yesterday said that there was a master agreement.
He did.
Signed addendum sounds consistent with the master agreement.
It does. It's not been produced. I'll show you the response from my learned friend solicitors. That's at page 435.
Hold on one second. Page
435.
35.
And here it is. So Mr. Nana says, in response to the query below, one, we did consider the addendum and determined that it was not responsive on grounds of relevance as the document relates to a different matter. So it seems that the lawyers at Pinson Masons, they looked at the signed addendum and they thought that it related to something different. And, I've got no reason to doubt that, and it's consistent with what
one explanation, of course, could be that the $1 million that your client gave was used in a different transaction.
It could well be. The constant theme that runs through the entirety of both cases is the paucity of information that is actually provided to the Ivankovich side. And then the second
well, that I see. I mean, the question is, of course, what inferences I can properly draw from the absence of any documentation.
Well, in my submission, you don't necessarily need to decide the question about whether there was a sale contract, because the only pleaded issue that this is relevant to is the counterclaim by KJM, because KJM says that as a result of Contessa not paying, KJM lost the money that it had paid to Sino-Eagle. And what my learned friend can't do is point to any contractual term about a payment schedule. And he can't point to any contractual term that entitled the shipyard to forfeit. Yes, the shipyard wrote letters saying we are forfeiting, but just because a party asserts a right to do something doesn't mean that it has in fact got that right. And I'd say, Your Honour, there is something remarkably odd about the fact that KJM cannot produce any document, whether it's an email, memorandum, whatever, that shows the agreement about the price, an agreement about the particular vessel to be purchased.
Yeah, I mean, yes, I mean, from your point of view as counsel, this is all sort of a very elegant submission, but sitting here as the judge, I have to make findings of fact. And one of the findings of fact is that I must decide whether or not there was in fact a contract of sale for this vessel.
Well, Your Honour has got those two emails. Your Honour has got the fact that there is no other disclosure, and Your Honour has got what Mr. Al-Jazmi and Mr. Hyrabad want to say in evidence.
Yeah.
And that is it. And Your Honour may come to the view that that is not sufficient to prove the existence of a contract, because if there were a contract, there would be some email where they say, yes, it's this boat with this hull registration number and these options, and this is the payment schedule. And I mean, because even Your Honour, just standing back, the 9th of August cutoff date that Sino-Eagle impose, where they say, beyond this date, we're just going to forfeit. Where's the contractual basis for that? Where's the term that says you must pay by this date or so many days after a notice or whatever? Nothing.
And the other issue of fact is it said that there was an initial deposit of $1 million, and then the other 1.6 was paid. But we never see a payment of 1.6 million, 0.6 million at any point. We see a number of other payments.
We do.
Which total more than 0.6.
Yeah.
But we don't know whether they were paid in respect of this transaction, if it existed, or other transactions.
No, and they are a dealer for Aquila. So the fact that they send money to Aquila with on a bank statement that says transaction reference Sino Eagle Aquila doesn't tell you anything about whether this payment is for any particular
No,
yacht.
and not one of the payments. And one would have expected if there was another, if the second tranche of the deposit was 600,000, one would have expected a single 600,000 payment.
Yes, and what's very odd is that certainly the way it's presented right at the beginning is to suggest, well, there's an upfront. The way it's presented to the Ivankovich family is to say, well, there's an upfront deposit of 1.6 million, and then a balancing payment of 2.99.
Yes.
But that doesn't seem to be what the real position is. But I don't know what the real position is.
Well, I mean, if you go to the loan agreement, as of the date of execution of the agreement, Contessa has paid 1 million point 6 deposit. So the whole basis of the loan agreement is the 1.6 was deposit.
Yep.
But on K. James' case, that actually it was only 1 million.
And that is what it appears like. We only found that out in disclosure.
Yes. Yes. Okay.
So as against, so just to return, Your Honour, to this question of when the Admiral report was delivered, the only answer to it has been an attempt to construct an alternative narrative that in fact it was delivered, but Mr. Ivankovich hadn't got the money and so was sort of trying to put everything off. And my submission just to that very briefly is that there really isn't much evidence for it. Mr. Ivankovich was very clear that that wasn't the case. That's day 2, page 95, starting at lines 3, day 2, page 117, starting at lines 14. A lot of weight is put on the fact that companies went into Chapter 11. But Your Honour might recall that all the payments on behalf of Contessa come from a company called Glencoe, which never went into Chapter 11. Indeed, neither did Contessa. The truth is the defendants don't have any real evidence on the Ivankovich family wealth. And Your Honour can understand something of it from Mr. Ivankovich's evidence that the family paid cash for the Sunseeker. That's
well,
day 2.
Yes, the Sunseeker seems to get ignored in K. James' evidence.
It does. And I mean, the Ivankovich family is a family who paid 11.5 million in cash for the boat. That's day 2.
And when was that paid?
I don't think we have that in evidence, Your Honour. But Mr. Ivankovich's oral evidence on that is in day 2 and starts at page 117. So in my submission, Your Honour can find as a fact that the Admiral report was received by Contessa for the first time on the 11th of July 2024, when it was sent by Mr. Radwan by email. And at that point, it is a year out of date. And the experts agree that a report that is a year out of date is not reliable evidence of the condition. So when Contessa is sitting there in July 2024 and receives a report that's dated July 2023, it's got no real idea what the condition of the vessel is. And it's obviously rational for a party in Contessa's position to say that's not satisfactory. The reference, Your Honour, it's in my skeleton, but just so you've got it, for the experts' agreement is page 327. And nothing about the corrective actions report changes that analysis. The contract didn't oblige Contessa to rely on anything that the shipyard said. And both experts accepted that it was not reliable evidence. That's also in the joint memo at page 327. And Mr. Folkes accepted it in terms at the end of his cross-examination. That's day 1, page 153. So to put it together for Your Honour like this, if Your Honour concludes that satisfactory in clause 2b includes the condition of the yacht, and Your Honour finds as a fact that the survey report was received for the first time on the 11th of July 2024, Your Honour can conclude that whether or not there was a Braganza duty, if there was such a duty, it was entirely rational for Contessa to say, as it did, that that report was not satisfactory. And therefore,
assuming
Contessa,
I'm satisfied that there was a contract for the purchase of this vessel.
well, yeah, yes, but to some extent, I don't need. If Your Honour is not satisfied of that, then that doesn't, I don't think, affect my case. If Your Honour is satisfied of that, I still succeed. So for all of those reasons, Your Honour, you don't actually need to get into the question of whether the defects that are identified in the report render the condition of the yacht unsatisfactory. But if Your Honour thinks that you do, I've just got 3 short points on them.
Mm-hmm.
The first is that these defects, snags, whatever you want to call them, are plainly more than merely cosmetic. Your Honour has already noted the issue with the air conditioning. Mr. Hung sets out several more. My learned friend sought to suggest that the air conditioning was just an error message based on a photo at page 1002. But the narrative that Your Honour has seen makes it quite clear that the air conditioning problem was worse than that. And there are other problems that are
at best, we just don't know, do we? Because at best, it could be a matter of adjustment. At worst, it could be under specification.
Exactly. And Mr. Hung does descend to that sort of detail. And there are other examples that are obviously more than cosmetic. So page 981, this is my personal favorite. If we scroll down a little bit, there's just a panel that's missing. So that's not cosmetic. That's just a part of the boat that either hasn't been manufactured or if it's been manufactured, hasn't been installed. So all the parts are just exposed. There's another one of those that we don't need to go to it at page 995. So the first point is it's plainly more than cosmetic. The second, and this is the critical point, Your Honour, is that now in closing, we know everyone thought that the yard needed to rectify these defects. That was Mr. Hung's view. And I'll just help Your Honour with that. At page 941, he gives his descriptions about consistency of reporting. And as my learned friend quite fairly pointed out, both good and satisfactory include no maintenance or repairs required, satisfactory, minor deficiencies not in need of correction. So good or satisfactory means no work needs to be done. But once you get, as Your Honour spotted, to 954, and we scroll down, he points out that quite a lot needs to be done. Require further alignment at 6, should be added around the edges at 7. If we go over the page, 14 and 15, he actually uses the word to be rectified. requires attention right at the end, shower hose to be replaced with new. So it's obvious that Mr. Hung thinks that work needs to be done. So what's the explanation? If we go back to 954, it's quite obvious what Mr. Hung is saying. If we just scroll up ever so slightly to the thank you, because Mr. Hung's conclusion is that the vessel is generally satisfactory to good, subject to comments as contained therein. Now, he can't be saying the vessel is currently satisfactory to good, because satisfactory to good means no work is required, and he thinks work is required. So satisfactory to good, subject to comments as contained herein, can only mean this vessel would be satisfactory to good if 1 to 24 are addressed. So Mr. Hung thinks these need to be fixed. Mr. Folkes was very clear in his evidence. KJM's expert, day 1, page 152, line 7, they do need to be remedied. You know, you're buying a brand new vessel, you expect everything to be in A1 condition, so yeah, they needed to be rectified. That's their expert. Mr. Al-Jazmi, when he was giving his account of handing over this survey report to Mr. Ivankovic, even he says, quote, I told him, that is Stephen, that the factory would make the necessary corrections. That's day 3, page 42, line 9. And he said, I wouldn't allow any boat to be shipped or to be delivered without checking it and making any necessary comments. Day 3, page 45. And he said that if something was wrong or incomplete, his employees would ask the shipyard to correct it. That's day 3, page 44. Now, KJM obviously did think something was wrong or incomplete because it actually asked the shipyard to carry out some works, and that's why the corrective actions document gets produced. So KJM thought these needed to be rectified, and obviously Mr. Ivankovic did as well. He said when he saw the report in July, it wasn't in a saleable condition. That's paragraph 30 of his witness statement, page 81. So no one thought this yacht was in an immediately saleable condition. And the third point on the defects is simply this. Even if your honour thinks, well, I think this would have been fine, I'd be happy to go on a boat like this. The question is whether it's rational for Contessa to say, actually, this condition isn't good enough. And in my submission, that's a rational decision for it to make. There's a logical connection between the reasons, i.e. there are some problems with the yacht, and the decision. And there's this point that emerged, and I'll just deal with it very briefly, that KJM could have corrected the defects. And so actually what could have happened is that KJM could have just accepted this yacht in the condition that it was in July 2023 and carried out the repairs itself. 3 points about that. The first is forensic. The first time that was suggested was in the Learned Friend skeleton. It was not suggested at the time. No evidence that anyone at the time suggested KJM could do it. Not suggested in the pleadings. And it's not suggested by any of the witnesses in any of their witness statements. So that's the first point. The second point, perhaps the most important, is evidential. There is no evidence before the court that KJM could have conducted the works necessary to rectify the defects. I mean, cleaning and polishing and scrubbing the toilets, obviously.
I thought the evidence was the other way. I thought the evidence was they couldn't, that they couldn't do it.
Well, Your Honour is quite right, and this is the crucial bit. Mr. Al-Jazmi and Mr. Hyderabad-Walla, in their witness statements, they don't say that KJM had the facilities to repair the defects listed in the report. The submission was pure speculation by my learned friend.
No, but I recollect, and I'll have to search the transcript, but I recollect that one witness, and I can't remember who
it was Mr. Ivankovich,
said that they were inland, and that they didn't have the facilities to lift a vessel, a 70-foot vessel, by crane, and take it inland.
It's day 2, page 13. It starts at line 2. It's Mr. Ivankovich, and that is the only evidence on the record on this question.
I don't recollect that being challenged.
No, I don't think it was. I'm a learned friend. Or he might have put he might have put in a general way that I should be fair to my learned friend. I think my learned friend put KJM could have cured the defects.
Well, I don't think there was a specific challenge about
this was the answer.
The need for lifting tackle and bringing a 70-foot boat inland. It would have to. I have some recollection of a suggestion that it may have been done at somebody else's facility. I don't know.
Well, what Mr. Ivankovich said is that KJM's facility is landlocked, so they'd had to have brought it out of the water, and they didn't have the ability to do that.
I'll look at the evidence on that. I'll look at the evidence.
The third point, which frankly is the answer to this point, irrespective of what you think about the evidence, is that the question isn't, would it have been reasonable for KJM to cure the defects? The question is it irrational for Contessa to have said, I think we should get the factory to fix this? And actually, Mr. Ivankovich gave the answer to this question at day 2, page 16, starting at line 14, which is that when you paid for a boat from a manufacturer, you're paying for the yard to construct it to a finished standard where it's complete. If you take it at a less than complete standard and do the work yourself, you're just paying twice for the same thing. And you might remember, Your Honour.
Well, it's Mr. Folks. It goes back to Mr. Folks again, doesn't it?
It does. And Your Honour might remember that Mr. Ivankovich said, well, you'd also have all these warranties. Again, we've not seen what the actual warranties are because they've not produced the contract. But, the idea that KJM might be just doing work that would otherwise be under warranty, like, for instance, the air conditioning, is just commercial madness. So, in my submission, it's almost unarguable to say that it is irrational for Contessa to say, actually, I don't want KJM to rectify the defects. They should be rectified by the yacht. So that's what I was going to say on breach.
Yes.
Just very briefly on this question of a Braganza duty, because I don't resolve from my case that actually there is in fact no Braganza duty. I set out the authorities for Your Honour in section D1, and Your Honour only has to consider this question of law if Your Honour is against me on the question of breach. But a few brief points. Firstly, my learned friend said, well, this duty can arise either by construction or implication. And my answer to that is, well, if it's an exercise of construction, there has to be some language for you to construe. Here, all there is Contessa's sole discretion. And if that term is to be confined, it can only be done by implication. And therefore, Your Honour has to be satisfied.
I mean, I find it hard to believe that where a document talks about a party's sole discretion, that it's permitted to exercise that discretion irrationally.
Well, for instance, if, there are rights that a party might have that it can exercise without any regard to the other party's interests, or indeed for a reason that is irrational, like, for instance, a bare right to terminate.
But I mean, it's a commercial contract, and looking at a commercial contract in that context, well, I've said I'd take some persuading that there wasn't a duty.
Well, the 2 points that I would urge on your Honour are this. The first is that in my submission, clause 2b is clearly for Contessa's sole benefit. It's putting up the cash. It hasn't seen the yacht. And what clause 2b is doing is giving Contessa essentially an option to say, we pay when we are satisfied that the yacht is up to standard. And of course, it takes the risk that it having already outlaid 1.6 million, that if it decides not to proceed, it might lose that money.
But if it's permitted irrationally to reject the yacht, essentially, that destroys the whole commercial purpose of the agreement, because it just means it could walk away.
Well, it's a bit like those authorities, isn't it, on that have held that there's no Braganza duty implied fettering a lender who lends on demand from demanding at any time it likes. And you might think, well, if I lend on day 1 and then I demand repayment on day 10, to some extent, commercially, the purpose of a loan might be destroyed completely. But the question is about whether this is the sort of right that a party is just entitled to exercise when it wants to, without any review by the court.
But this is to facilitate the purchase of a yacht, in relation to which KJM will have, all things being equal, incurred liabilities to a third party, the yard. And what you're suggesting is that Contessa could just shrug its shoulders and say, tough. I'm walking away from this because I feel like it. I mean, it doesn't make commercial sense to me.
Well, I've set out my submissions in my skeleton.
Well, I've told you my thoughts.
Yes, I'll perhaps leave it there. So I'll move on to deal with this question of waiver.
Yes.
And there is an important preliminary point here for your Honour, and that is what case is actually available to KJN in closing. And in my submission, the only case that is available is that which is pleaded. And it's worth just going back and looking at the pleadings. It's at page 23. Thank you to the operator. And the plea is at 39.2. And at little 1, 2, and 3, you get the pleas in relation to the Braganza duty, which we've dealt with. And then at 4, there's a plea that Moore & Co.'s request on 30th of July 2024 for wire instructions to advance the sums as envisaged under the loan agreement indicates that by that time, Contessa was satisfied with the survey report and accepted the payment was due. KJM relied on that request in believing that the required sum would be paid by 3rd of August. And then at little 5, it continues, in the further alternative, Moore & Co.'s request for wire instructions amounted to a waiver of the condition precedent, such that Contessa was obliged to advance 2.3 million. In the further alternative, the request for wire instructions gave rise to an estoppel. That is it. So the pleaded case is that Moore & Co.'s request for wire instructions, and you can see the express plea in relation to that actually at page 22. You can see it's paragraph 35. There's a plea on 30th of July 2024. Moore & Co. requested wire instructions for the transfer of 2.39 and 36 the same day in reliance on and in accordance with the request for wire instructions, KJM provided an invoice. So that's the only thing that Contessa, that KJM is alleged to have done in reliance on the alleged representation, is to have sent an invoice for payment of 2.39 million. So this is the case that is open to my learned friend in closing. That 30th of July 2024 email, we'll come to look at it in a minute, but it's at, well, it appears several places in the bundle, but 1296, if you'll wish to note. In my learned friend's skeleton, as I outlined in my opening, there's an entirely new case. So, and it's at paragraph 43, supplementary bundle 1104. We don't need to go there in a moment, thank you. But what is said is it's a failure to say anything at all about the Admiral report, and then alleged promises to pay between October 2023 and March 2024. It's a totally different time frame. None of that you'll find anywhere in the pleading. And the case is, well, KJM relied on those statements when it sent money to Sino Eagle. And because none of this is pleaded, it's not open to KJM to close on this basis. There's no application to amend, nor could there be. And the reason is that it would cause real prejudice to allow this case to be run now when it's not been pleaded. And I'll give you just one example. The factual case, the new factual case, is that KJM paid money to the shipyard in reliance on what was said in October and November and March. That is an issue.
Just on that.
Yes.
Is there any evidence anywhere of the price agreed between the shipyard and KJM for the vessel?
Not that I'm aware of. And their witnesses, neither Mr. Al-Jazmi nor Mr. Hyderabad, well, I'm sure Mr. Page will correct me if I'm wrong, but I don't think either of them say this was the price that we agreed to pay. And that one would assume it was just less, it was the $3.9 million. But
I don't make any assumptions.
No, well, neither do I. But just to finish this point off about why there would be real prejudice, is because the factual case that's now run is that in reliance on what Mr. Ivankovich said in October, November, March, KJM paid money to Sino Eagle that it would not otherwise have paid. And that is a factual question on which Contessa, if it had been pleaded, would have sought document production, because it's very unclear what the actual payment schedule was. And there's no evidence.
Well, it's not a matter of unclear, we just don't have any evidence at all.
No, and there would surely have been internal emails and emails between, so internal emails at KJM about making these payments, or WhatsApps or whatever, and there would be correspondence between the shipyard and KJM.
And presumably, sorry, running ahead slightly, had Mr. Ivankovich been appointed a director of the company and had independent auditors been appointed, the documents in relation to the transaction would have been available to Mr. Ivankovich.
But potentially, I think there's a bit of a dispute between the parties about whether the this transaction between Contessa and KJM sort of falls under the umbrella of the JV. But I'm not saying no to you on that. I'm saying that's not quite clear. It may have been as a matter of practical reality that he would have had access to those documents. But to give an example, imagine, for instance, that KJM made those payments to Sino Eagle because that was the contractual payment schedule. Very difficult for KJM to say that it made those payments, therefore in reliance on anything Mr. Ivankovich has said. But we just don't know. And this is this is the consequence of trying to take a new factual case in your skeleton. In fact, this whole waiver case was not addressed in my skeleton because the first time it came was in the skeleton argument. Is that
but we keep on coming back to, and you'll gather that it's rather significant to me that there is no evidence of the contract between KJM and Sino Eagle.
No.
I mean, that's the source of all of this problem.
It is, and one of the reasons why there is no evidence about the payment mechanics between KJM and Sino Eagle is because this point wasn't pleaded and was only taken in the skeleton, and therefore Contessa had no opportunity to seek document production about it.
Yes, I mean, that's how the broader question plays into this narrow question.
Yes, it is, Your Honour. It is. So in my submission, the only case that is open to KJM in closing is that which it is pleaded. And so I'm going to address that very briefly first. What I thought I would do, Your Honour, is just quickly cover the law. And then with an eye on the time, we might we're coming up to the 10-minute break. I might cover the law on waiver, because I think I can do that quite quickly. And then we can take a break and I'll carry on. So I was going to take the law on waiver from my learned friend's skeleton, because actually, as I said,
I'm sure he's flattered. I'm sure he's flattered by that.
Well, I'm going to say, if I may, with respect to my learned friend, that I don't disagree with anything that he says, subject to one quibble. It's at page 11. Sorry, well, in the it's page 25 of the skeleton. Is perhaps the easiest way of getting there for the EPE. It's in the supplementary bundle at page 1103. So my learned friends relies on three different types of waiver: waiver by election, waiver by estoppel, and estoppel by acquiescence. If I could ask the EP operator just so you can see the entirety of para 42, that'd be very helpful. Thank you. Now, I don't disagree with anything that my learned friend says about what waiver by election means. My only quibble here is that this is not a case of waiver by election, because election is where a party's got inconsistent rights and it makes a choice, and the effect of that choice is to close off the exercise of any other rights. So if you've, as my learned friend rightly says, if there's a breach and the innocent party chooses to affirm, it loses its right to terminate for repudiation. So my learned friend's statement of the law is entirely correct. It's just wholly irrelevant to the situation that Your Honour's dealing with. If there is any waiver here, it's waiver by estoppel, which is, as my learned friend quite accurately summarises, requires essentially three things: an unequivocal representation by words or by conduct that the party doesn't intend to enforce his legal rights or doesn't intend to rely on part of the contract. So what Your Honour will be looking for is an unequivocal representation that clause 2b doesn't need to be applied. So Contessa is saying, we will proceed as if clause 2b does not exist or doesn't need to be enforced. And then the other two legal requirements are there must be reliance. So the other party acts or desists from acting in reliance on that representation, with the effect that it would be inequitable for the representor to go back. I mean, the authorities are a little unclear as to whether you need actual detriment, but what there, my submission, what there has to be is some change of position on behalf of the representee to make it inequitable for the representor to insist on his legal rights. And finally, my learned friend refers to estoppel by acquiescence. And I would say, I don't want to get too academic about this, that this isn't actually, if one looks at the authority he cites, and the critical paragraph is paragraph 52 of the F&T case. I'll just give you the reference in case you want to look at it. It's in the supplemental bundle at page 864, is that it's not actually a separate species of estoppel or waiver. It's just that in certain circumstances, if a party doesn't say anything, that conduct can amount to an unequivocal representation. Pretty unusual, and it's not the pleaded case, so Your Honour doesn't really need to worry about it. But that was all I was going to say about the law of waiver. It's relatively clear and established. I was going to move on to actually deal with the waiver case as pleaded. Now might be a convenient time for a 10-minute break.
Yes, let's do that. A bit less than 10 minutes if we go to 25 past. Let's come back. We can take a slightly longer break and perhaps even a shorter lunch. Let's come back at 1/2 the hour.
Okay.
Okay, thank you. Just wait for Mr. Page. Okay, let's proceed. You're on mute.
It happens to each of us. I was going to deal with the three, with the waiver case as actually pleaded. And I've got 3 short points. The first is that there was no unequivocal representation that clause 2b did not need to be complied with. And if we could ask the operator to go to page 1305 in the bundle and just scroll down at bottom email. So this is the wire instructions email that is said to amount to the unequivocal representation. In my submission, it obviously is not. There's a number of points. This email comes only a matter of days after Casey Flipman has sent that email that I showed you on earlier at page 1302. We don't need to go there now, where she says, the report's not satisfactory. It's a year out of date. It's obvious that what's going on is Mr. Ivankovich is stepping in and saying, look, and this is an attempt to save the transaction, I will buy this boat personally from the shipyard. That's why Michael Moore says provide draft documents saying the vessel be transferred upon receipt of payment to Stephen Ivankovich or assigns. And it's why he's asking for wire instructions, because by July 2024, the Ivankovich family have sent over $3.5, if not close to $4 million in total to KJM. They don't need wire instructions to send things to KJM. What they're after is the wire instructions of the shipyard. And it's obvious that it's understood by KJM what's going on, because if I can just ask the operator to scroll up, you get Mohammed Radwan's response. And his first response is, well, in accordance with the loan agreement, the contractual route is to wire the balance to us. But then he says, this is about 3rd lines down, in case Contessa Research would like to have the yacht under the name of Stephen, kindly direct the purchase to the factory and KJM will process all the documentation. So he gets that. What he's saying is, if what you want to do is just buy this yacht, process all documentation, we'll deal with that. And what's the final email in this exchange? You want to see it, I think, now a number of times. It's at 1323, which is the last exchange. It's from Michael, and he says, well, look, Stephen is still willing to close, but what you need to do is give us the name and contact information for someone at the yard and let us do a pre-delivery inspection. Now, in my submission, when your honour stands back, there's no representation, let alone an unequivocal representation, that somehow clause 2b doesn't matter or isn't being relied on. At this stage, frankly, the loan agreement has fallen away. It hasn't been complied with. This is about Stephen saying, well, I'll step in. I mean, you might think, Your Honour, is very revealing that we weren't put in touch with anybody at the yard. Maybe that goes to Your Honour's query about whether there really was a sale contract.
Yes. So the response to this email,
there isn't one.
So there's no response.
There is no response.
And the termination, just so I've got the chronology. Termination
is on
follows.
The letter from Sino Eagle where they say they are terminating is on the 9th of August. That's at page 1282.
So what correspondence is there between this?
There isn't any.
So this is the 2nd of August. It's the American date.
Yeah.
Okay.
And then
but there's nothing between then the 2nd and 9th of August.
No.
So you say that this letter or this email?
I don't. I'm just showing it to Your Honour, so Your Honour's got the chronology.
Yes, but I mean, what you say, sorry, you say the context is, well, item 3 that Mr. Ivankovich is saying, I will buy if it's delivered to me.
Yes, sorry, yes, you're looking at that letter, yes.
And nothing happens in relation to that.
No. There's no response to this email.
Okay.
So the first point is no unequivocal representation. And the second point, and this is, if I can put it in these colloquial terms, the killer, is that there is no reliance on the wire transfer email. Neither Mr. Al-Jazmi nor Mr. Hyderabad say anywhere in their witness statements that they relied on the wire transfer email. So that's just fatal.
But coming to the context of it, you say that the wire transfer email was in the context of Mr. Ivankovich purchasing the yacht.
Yes, yeah. So but this is Judge, even if Your Honour thought that the wire transfer email could be a waiver in some way, there's no reliance, and more importantly, there's no change of position by KJM in any way. because by this point, whatever KJM has paid to Sino Eagle, it's already been paid. So this wire transfer email, KJM doesn't do anything, nothing meaningful anyway. It sends an invoice, but it doesn't do anything in response to that email. So even if it was a representation, and even if there were evidence of reliance, there's nothing that makes it inequitable for Contessa to say, no, these are the terms of the agreement. And that, I might say parenthetically, that's why, to give him his credit, my learned friend is trying to run this new case, because he knows that the case that's pleaded just doesn't work on the facts, because there's no reliance and there's no KJM doesn't change its position in response to this email. That's why if there's going to be a waiver, the case has to be, well, KJM paid some money in response to what Stephen said. But that case is not pleaded, as I say. The third point, just very briefly on this waiver point, is you've got the contractual clause. I won't go back to it. I'll just give you my submissions very briefly on it. The clause deals with modifications and amendments. So it's plainly wider than just a variation. So it deals with modifications. In my submission, that's wide enough to include a waiver. That's the first point. And in relation to ROC advertising, it doesn't help my learned friend, because actually the test, and he took you to it in opening, it's paragraph 16, page 728 of the supplemental. We don't need to go there. But the very last sentences of that paragraph, Lord Sumption makes clear that whilst waiver and estoppel can be an answer to these sorts of clauses, you need a representation that the party isn't going to rely on the informal modification clause. So, and he says that the original waiver or estoppel that would be defeated by the clause can't be that representation. So the party has to go even further. So imagine we had a contract, Your Honour, and I said to you in writing, I'm not going to rely on clause 2b, and don't worry about clause 15. I'm not going to rely on that either. And Your Honour paid some money or something in reliance on that statement. That might be enough. But that's not even alleged here. Now, I will just very briefly, in case Your Honour, contrary to my submissions, considers the case open to KJM, just deal with the unpleaded waiver case. I can do it very, very quickly. If we could just go in the supplemental bundle to page 1104. This is my learned friend's skeleton, and we scroll down a bit further, please. And we've got A, B, C, and if we could just, can we fit them all on the page? D. So these are the alleged representations. I'll just deal with them very quickly. A is an email from KJM to Stephen. So that can't be a representation by Contessa. 2, B, is a WhatsApp message. That's a message that says payment is ready to be set up, but it doesn't say when any payment is going to be made, and it says nothing about the contractual terms. So that's not an unequivocal representation. C, so this is the third one that's relied on, an email from Mohammed to Stephen of 8th of March. That's an email from KJM. So that's not a representation by Stephen. And in any event, that records that Stephen was making the payments for the Aquila conditional on something. So that's not a waiver by Contessa of anything. It's not Contessa saying we are definitely going to pay. If anything, it's Contessa making clear it's not. And then finally at D, there's an email about liquidation and freeing up capital. Again, it's not saying there's no need to comply with the agreement. And in any event, Your Honour, there is no evidence before the court that KJM relied on any of these things when it paid money to Sino Eagle. Mr. Al-Jazmi doesn't say that. Mr. Hyderabad Waller doesn't say that. There's no evidence of reliance. And Your Honour and I have already talked about the absence of any documentary evidence about why those payments were made. There just isn't any. So for all those reasons, Your Honour, Contessa wasn't obliged to lend. There's no breach. The issue then is an obligation to repay. We could just go to the trial bundle now, page 904. And this is the issue about the obligation to repay. The obligation to repay is under clause 5. In the event the vessel is not purchased by KJM, KJM shall return all funds. The construction of that is clear. There is an obligation to repay, and it is conditional simply on the vessel not being purchased. And that's consistent with clause 4A.
But
because
I mean, the case against you is on its proper construction. That means that if KJM decides not to purchase, not that the purchase falls through due to default on the part of your client.
But Your Honour is only considering this issue if Your Honour has concluded that there is no fault. Because actually, the way this contract works is quite clear. The loan always has to be repaid unless Contessa commits a breach. And that is because the loan is either repaid because the yacht is purchased and sold, or the yacht is not purchased and then clause 5 kicks in. And then if we go over the page on page 905, there's clause 6B, which says Contessa be deemed to be in default upon the occurrence of any of the following events: failure to make timely payment of money. In the event of default by Contessa and failure to cure, KJM may elect to do any of the following: sell the yacht and retain any payments. So the contract is clear. The only circumstance in which the loan monies are not repayable is if there is a breach by Contessa. And Your Honour is only considering my claim for repayment of the advance if Your Honour has concluded that there is no breach by Contessa. And in those circumstances, the contract is clear. If the vessel is not purchased, the loan has to be repaid. And this must have been contemplated by the parties, because the parties have agreed that Contessa will have a discretion about whether a report is not satisfactory. And so the parties must have contemplated that there could be circumstances in which Contessa says this report is not satisfactory. And what happens then? Well, the contract is very clear. If the vessel is not purchased, KJM shall return all the funds. There's the submission, Your Honour, that Contessa didn't in fact make payment, and that is in some way relevant. KJM says, well, Contessa has to prove its loss. The obvious answer to that is no, it doesn't, because clause 5 gives rise to a debt claim, not a claim in damages, because there is an express contractual obligation to return the funds. And in any event, as I made clear in opening, this case is just not open to KJM because they positively plead that Contessa paid the first tranche. And that is in the defence and counterclaim, paragraph 9 at page 19 of the bundle. So there's just no case available to Mullen and Friend. If Your Honour is, I should say, there's an issue about interest. It's addressed in my skeleton. I don't propose to say anything more about it at this stage. If your honour is against me and your honour concludes that there is a breach, then I accept that my learned friend in principle has a or KGM, I should say, has a counterclaim for damages. The question is, can it prove any loss? And the loss is put in two ways. There's a loss of profit claim. That's if we go back to the supplemental bundle, page 1107. This is the way that my learned friend puts his loss of profit claim. There's absolutely none of this. If we just scroll down a bit further, please, so we can see the table. He gives his calculation. None of this is pleaded, but I just want to walk your honour through it. So what is said is that your honour can infer the likely market sale price from one paragraph of Mr. Al-Jazmi's witness statement and one WhatsApp, which is the second bullet point. Your honour knows absolutely nothing about those, I'm going to put them in inverted commas, offers. You don't even know the name of who apparently made those offers, nothing about their means. I mean, anyone can make an offer. I can go down to the Excel Centre for the next yachting convention, make an offer to buy a vessel for 11.5 million. That doesn't set the market price unless I'm a credible buyer. So your honour's got no expert evidence about the retail price for these boats, no expert evidence about the market. There is, for the first time, proposed a notional sale date of 31st of January 2024. That's not pleaded. But why the 31st of January 2024? We didn't even have the corrective actions report until the 29th of February. There's just no real case on when this boat should have been sold. It's agreed by everybody that in this calculation, one would need to deduct selling expenses. That's his stage 2. And KJM allows $20,000 for 3 months. And if one looks at the footnote, this is similar to storage costs charged by Sino Eagle. Well, what are storage costs charged by Sino Eagle got to do with the selling expenses of a yacht? I mean, my learned friend, this is, sorry, Your Honour, this is the back of the fag packet. Your Honour has no proper case supported by evidence as to what profit KJM would have made if in fact this boat could have been sold. So Your Honour must just dismiss that claim for loss. And then the only other claim for loss is the monies that were paid to KJM, to Sino Eagle. We've discussed this at length. There's no evidence that that was forfeited. And that's
There's no evidence that the figures at 51 were paid in respect of this vessel.
There's certainly no documentary evidence to that effect. And then, in any event, we would say, and it's set out in my skeleton, the 1.6 million came from Contessa. And if that money is well and truly gone, that's a loss that Contessa has suffered, because the effect of the breach is to relieve KJM of the obligation to repay that money to Contessa. So if KJM has lost 1.6 million to Sino Eagle as a result of this breach, it's also been relieved of the obligation to repay that money to Contessa. So it's neutral. So the loss could only be about 240,000. That, Your Honour, was everything that I was going to say about the loan claim.
Yes.
I was going to move on very quickly to the JV claim. I'm very conscious of timing. I may need to seek Your Honour's indulgence for an extra 10 minutes or so.
Just before Mr. Watson does move on, I just want to check whether he does have anything to say about why interest should accrue from 26th of May 2023. Obviously a matter for him, but just want to flag that that's a point that hasn't been addressed anyway yet.
I can address it in reply if I need to. On the JV claim then, Your Honour, the first question is termination. And I'm going to adopt the same headings that I adopted in my opening for the various ways in which the termination case is put. The first is about the relationship to the Chapter 11 companies, because it's their entry into Chapter 11 that is said to trigger the right to terminate. Now, Mr. Ivankovic's evidence is that he doesn't own them, they're not his assets. His evidence was that payments had to be signed off by his father. That's day 2, page 139, line 22. There's no documentary evidence anywhere that these companies are owned by him, or that their assets are owned by him. Indeed, the Chapter 11 proceedings had his father, Anthony, and his mother, Olga, as the plan proponents. That's at page 1647. So Malone Friends' case is entirely inferential and based on Mr. Ivankovic's ability to procure payment. But that's not good enough to make good the case. Your Honour, as perhaps I will as well, be familiar with, for instance, the son of a wealthy Emirati, and he walks into a showroom and says, I'd like to buy that sports car. And the dealer says, yes, that's fine. And the son of the wealthy Emirati phones his father and says, I want to buy a sports car. And father talks to his people, and a company somewhere makes a payment to purchase the sports car. Now, just because the son in that example is able to call on the family wealth under the control of the patriarch does not in any legal sense render the companies as belonging to the son, nor indeed their assets. So the mere fact that Mr. Ivankovic is able to ask his father or his father's staff, more probably, to procure payments on his behalf does not tell you anything about ownership. In that case, in my submission, just doesn't work. Let's just look at the clauses that are relied on very briefly back in the trial bundle, page 886. And so the first clause that's relied on is KA3. And none of this is engaged. So if we just go through it briefly, if any venturer makes an assignment for the benefit of creditors, well, that's not happened, or petitions for the appointment of a trustee or receiver of the venturer or any substantial portion of the assets. So there has to be a petition for the appointment of trustee or receiver, either over the venturer or the venturer's assets. There was never a trustee or receiver because the debtors remained in possession. That's page 1651 of the Chapter 11 order. So that's not satisfied. And then it's, if any venturer commences any proceeding pursuant to any bankruptcy, blah, 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 that's got to be commences proceedings in relation to their own bankruptcy, reorganization arrangement, or insolvency. It can't preclude a venturer from, say, as creditor, bringing proceedings. It's got to be about the venturer commencing their own proceedings. And the venturer here is Stephen Ivankovic personally. He has never commenced any proceedings personally. The Chapter 11 companies commence the proceedings. That's 1651. And Your Honour can't just ignore separate legal personality in that way. Malone Friend says, well, Stephen should be treated as the effective applicant because his divorce proceedings caused the Chapter 11. But that doesn't satisfy the requirements of this clause. So that doesn't work. The other clause that's relied on is JA3. If I could just ask the operator to scroll up. Sorry, it's there. That's it at the bottom of the screen there. So there has to be a material change in the venturer's management, business assets, or company structure. If Your Honour is with me that actually these companies aren't Stephen Ivankovic's business or assets or company structure, he's associated with them, but they're not his. That clause isn't satisfied. In any event, there has to be a material change, and we both agree that material is material to the performance of the JV. And my learned friend can point to no obligation in the JV agreement after the Chapter 11 that Mr. Ivankovich is unable to perform. So in my submission, this clause isn't satisfied either. Moving on to the divorce orders, just for your honour's notes, the three orders are at page 898, 1097, 1099. Again, the clause that's relied upon is this clause JB3. So once again, there has to be a material change to Stephen in the required way.
What was the third? Third one was 1099.
1099. That's the body attachment order. I think at this point I should just make a correction to my skeleton, because I think I said at page 149 that the 425k had been paid before the contempt order, and Mr. Ivankovich clarified in his oral evidence that that wasn't right. So I withdraw that part of my skeleton, but it makes no difference because the money order was made in May 2023. So that is before Mr. Ivankovich procured the payment of the 2.25 million to the JV. So there is no basis to say that the making of that order in any way materially affected Mr. Ivankovich's ability to perform the JV. His principal obligation was to pay in cash contributions, and he paid them. These orders were just found long after the event, and they're being deployed now. It's not a ground of any real substance. That brings me on to the question of late payments. And there are really 2 points. Firstly, that the payments were not late. And secondly, that in any event, the defaults were cured. On lateness, let's just go to page 882. So the initial contribution had to be made within 30 days of the execution of the agreement. And you see that at C at the top. This is the 2 million bullet payment, I think, as my learned friend put it in cross. And Mr. Ivankovich's answer was, well, I couldn't make the payment until KJI had been incorporated, and it was put to Mr. Ivankovich that the contract didn't stipulate that payment had to be made to KJI, and that is flatly wrong, because you can see from clause, it's another clause C, but it's just above clause D, additional contributions, that Ivankovich's initial contribution shall be an interest-free shareholder's loan. Now, who is the shareholder making the loan to? KJI. So the parties agreed that the form of the initial contribution isn't just a payment of money, in an amorphous sense. It is a loan to KJI. And how can Mr. Ivankovich make a loan to a company that does not exist? KJI was not incorporated until July 2023. And by then, there had already been the variations to this JV agreement. So there was no initial breach, as my learned friend likes to suggest. Let's just quickly go to the variation that matters, which is at 913. The first tranche was due on June the 19th. Everyone accepts it's 3 days late. I don't think my learned friend suggests that's a breach, because clause KA1 requires a default that lasts at least 14 days. So that's just irrelevant. The real question, if we go over to page 914, is when these two tranches are due, and the first is due within 5 business days of obtaining all the approvals for the build-up. Now, my learned friend suggested in cross-examination that that just meant the industrial license, but it obviously doesn't, because one only has to look up to see that it's under licensing, for instance, regulatory and operational licenses, including but not limited to, then a whole series of licenses. And if we go up again under construction, consultancy and associated logistics, there are mandatory pre-approvals for municipalities, civil defence and DEWA. And what's the significance of this, for your honour? Well, if KJM is going to advance a case that Mr. Ivankovich was in default, it has to be able to satisfy your honour as to when the due date was. And it has not adduced any, well, let's take this in stages. There is no pleaded case about when tranche 2 was due. What does, upon obtaining all approvals for the build-up, actually mean? No case on that. But there's no evidence about it either. It obviously means more than just the industrial license. No evidence. So KJM cannot show that Mr. Ivankovich paid late. And the same is true with the mould arrivals. The case seems to have been that Mr. Ivankovich agreed to provide the physical moulds, didn't, and so KJM just used some other moulds. And your honour might recall in cross-examination, I showed how in the original JV agreement, there's no obligation on Mr. Ivankovich to provide physical moulds. His obligation was to provide the capital for the moulds. So what you get, actually, in fact, is an email at 1137, which is where this money is demanded. We don't need to turn to it, but I'll just very briefly give my submissions on it, where essentially KJM says, well, we're just going to use our own molds, and now you need to pay us some money. I mean, that is a party unilaterally changing the terms of the bargain. It does not establish that money was in fact contractually due. But in any event, all of this is to some extent irrelevant, for your honour, because there is no dispute between the parties that all the money was in fact paid. So the only question is, could they lawfully terminate as a result of these delays? And the answer to that is no, because if we go to page 886, back in the JVA, KAB is very clear. Should an event of default occur and continue beyond any grace period, the non-defaulting party shall at its election have the right to exercise one of the following remedies to terminate. So the contractual remedy of termination only arises if, 1, an event of default occurs, so there has to be money due, and then a demand in a period of 14 days when it's not paid, and then that default has to continue beyond any grace period. And the obvious meaning of that is that the default has to be continuing when the right is exercised. It's very common in commercial agreements where there's an event of default provision for the right, for various rights consequent upon the event of default to be exercisable only if the default is continuing. And my learned friend says, well, that's wrong, because once the right to terminate has arisen, it cannot be lost. And here, unfortunately, he is wrong about the law. And I'll just take you back to his skeleton.
Well, can we just
yes.
unravel this slightly? So if there's reliance on KA1, then there has to be a demand, and the default continues for 14 days thereafter before you can go to KB.
Yeah.
So where is the demand that's relied upon?
Well, I might leave that to my learned friend, because if you think about it, Your Honour, firstly, KJM has to say money is due on a particular day, And then it has to say, after that day, we made a demand. And then there has to be a default continuing for a period of 14 days. My submission is they don't even have a case, let alone evidence on when the money is due before you even get to the question of demands. So I'll leave my learned friend to see how he wants to put his case. But whatever the answer to all of that, they couldn't terminate in December. Sorry, they couldn't terminate in September 2024 for a default that had been cured in December 2023 because KAB requires the default to be continuing. And if we go to my learned friend's skeleton argument in the supplemental bundle at page 1119, my learned friend cites the decision in Supermax, but you can see from the quotation that is extracted that Supermax is dealing with a case of repudiatory breach. That's a situation where a party exercises its common law right to terminate. And there, I agree. Once a party has committed a repudiatory breach, the innocent party is entitled to terminate unless and until it affirms. But there's no case here of repudiatory breach. The case is quite squarely termination under a contractual provision. That's the defense and counterclaim, paragraph 42.2, page 550 in the trial bundle. We don't need to go there. In fact, there is no reference to repudiatory breach anywhere in the defense and counterclaim. So my learned friend at KJM cannot run a case of repudiatory breach now because it would need to be pleaded. There would need to be an investigation into whether those late payments were repudiatory. And I would be entitled to run a case of affirmation because a party that just leaves a contract in existence for 9 months, I would say, in my submission, affirms. But Your Honour doesn't need to get into any of that because there's no question of repudiation alleged. The only issue is, was there a valid termination under the contractual provision? And the contractual provision quite clearly requires there to be a continuing default. And if Your Honour needed authority for that, you've got in the bundle Lewison, paragraph 17.126. We don't need to go there. It's in the supplemental bundle at 1033. If you terminate under a contractual provision, there must, quote, be substantive compliance with the contractual provisions. So the fact that any default, if there was one, has been cured is a complete answer to that ground. We come on to then the additional contributions. This is the renewal of the lease and the industrial license. The case is put, if we go back to the main trial bundle, on 882. The case is put, 882, that's my fault. Thank you. Under little d there in the middle, any additional contribution that should be required by either venturer must be approved by each venturer unanimously. There was never any approval by Mr. Ivankovich to make any additional contribution beyond the 2 million. That is the complete answer to this case. Indeed, it wasn't even put to Mr. Ivankovich that he agreed to make any kind of contribution. It was put to him that there was a need to pay. That was day 2, page 165. That need to pay is irrelevant. It was suggested it would be commercially unreasonable for him not to agree, but that's irrelevant as well. What matters is an agreement. There's not even a pleaded case about an agreement. But if Your Honour overlooks that for the moment, there's no evidence anywhere of any agreement by him. And so that, in my submission, is the complete answer to that additional contribution claim. I will move now just to deal very briefly with the question of remedies, because once you've answered those 4 questions, there's no ground to terminate. So the JVA remains in force. And the question is simply whether you should enforce it. And here the answer that comes back from KJM is to say, well, the memorandum of association superseded the JVA. That's the way the case is put. Again, bit of a theme here, not a point that's ever been pleaded, but in any event, it's wrong. I can deal with it like this. We just go to the JVA, to the MOA. It's at page 1038. What is this document? This is the constitutional document for KJI. It's its Articles of Association. It says in it, nowhere does it say in it, that it supersedes the JV agreement. It doesn't even refer to the JV agreement. There is nothing in Dubai law, or indeed in English law, problematic about forming a company, having Articles of Association, and then having a separate contract between shareholders about how they will exercise their rights. And that is exactly what the parties have done in the JV. So if we go back to the JV for a moment, what have the parties agreed? If we go back to page 884, say, we can see what the parties have agreed. They've agreed that there will be 3 directors. They have agreed on the previous page at 883 how profits are going to be shared between them. And at 885, there's an agreement about the books and records and about a biannual audit. And this is why the enforcement, Your Honour, of the JVA is so important, because Mr. Ivankovich obviously has the Dubai law rights that he has as a shareholder of KJI. He's got those already. But what the JV agreement gives him are additional contractual rights. The parties have bargained for more. How does this work contractually? Your Honour might be thinking, well, the answer is to be found, as it usually is, in Chitty. And if we go into the supplemental bundle at page 999, you get implied terms. 999.
Yeah.
Where you go in an emergency. Cooperation, you get the classic statement of the rule. As a general rule, where in a written contract it appears that both parties have agreed that something shall be done, which cannot effectively be done unless both concur in doing it, the construction of the contract is that each agrees to do all that is necessary to be done on his part for the carrying out of that thing, though there may be no express words to that effect. That's the classic statement. If we just go over the page, the editor's note, notwithstanding the reference to a general rule, the term is not an inevitable feature of a commercial contract. The requirements for the implication of a term into a contract must still be satisfied before the implication be made. The term is most likely to be applied where positive cooperation between the parties is required to bring about a particular end contemplated by the contract. So let's take an example of the practical significance of this. And actually, Your Honour, perhaps unwittingly, in cross-examination, Mr. Al-Jazmi's cross-examination got to the very heart of this. How does Mr. Ivankovich become a director of KJI? There has to be a General Assembly meeting, and there has to be more than 50% of the votes, which means KJM has to vote in favour of Mr. Ivankovich's appointment as a director of KJI. So if we go back for the moment to page 884, in the main bundle, What is the proper construction of clause FA? It is a contractual promise by KJM to do all things that are necessary to procure that result. And the result is that Stephen Ivankovich is a director of KJI. And what does that require? It requires KJM to vote in favor of Mr. Ivankovich's appointment at a General Assembly. And that is a contractual obligation that Your Honour can enforce by way of specific performance. And that is what the JVA claim seeks. And that's the way, and that, if I might say, standing back, is the logic behind the JV claim. Because the way it was put by Malone Friend in closing is to say, well, Your Honour shouldn't be making orders to make these people work together. And that is not what the JVA claim seeks. What it seeks to do is orders compelling KJM to perform those bits of this agreement that it should have already been performing, to put Mr. Ivankovich in the practical position that he should have today, that he should have been in from the start. That is a director. He is a director. There is a proper auditor. And he's got access to the books and records. And Your Honour can achieve that result by specifically performing this contract. Now, in opening,
I don't know why you said that my intervention was inadvertent.
I didn't
That's
mean
all
to
right. I'm
suggest
just teasing.
I didn't mean to suggest it was inadvertent, but I think Your Honour had grasped the heart of the matter there.
Well, this is a shareholders' agreement.
It
Shareholders' agreement typically
has to be enforced.
Well,
And is
not just have to be enforced, but shareholders' agreements govern the rights between the shareholders.
And if a shareholder doesn't do what doesn't procure the result that is provided for in the shareholders' agreement, the court can enforce it by specific performance. Now, in opening, my learned friend said, and I quote, that the pleaded case only gives a hint, sorry, he said a small hint, of what has actually emerged in the draft order. That was day one, page 41, line 22. That is just wrong. And if we just go to page 534 in the bundle, these are my particulars of claim from September 2024. You can see at paragraph 44, there's the claim for a declaration as to termination. And then I'd encourage Your Honour, when Your Honour's writing his judgment, to read on. Claim 2, appointment of directors, you see over 2 pages set out the basis for the orders that are sought. If you just scroll over page 47, paragraph 47, in particular, the claimant claims orders that, and then all the orders that are claimed by way of specific performance are set out. If we continue to scroll down, you've got the auditors, scroll down even more. Keep going, keep going, keep going. There's a lot of pleading. There we go. Claim for provision of documents. The pleading is longer than the order. So Malone Friend can't say that he's in any way surprised about the relief that's being sought, because over more than 5 pages of pleading, the relief has been set out. The reality is that KJM just has no answer other than its termination point as to why this relief shouldn't be granted. I'll turn now at the end just very quickly to KJM's counterclaim. I've dealt with most of the alleged breaches already. The only breach that isn't relied on for termination, but is still said to be a breach, is a breach of Mr. Ivankovich's obligation to market and sell vessels. That's if we look at page 884 of the bundle. Here, this is the contractual obligation. It's you see the heading Ivankovich. You see the venturers agree to a division of authority between themselves under Ivankovic. You've got Ivankovic who manages his own business. And then this is the term that's relied on. Ivankovic will be in charge of marketing and the sale of the vessels in the Middle East and the United States of America, according to his business practices and experience. This is a term that Mr. Ivankovic is alleged to have breached. Now, obviously, I would say, firstly, this doesn't impose on him an obligation to market and sell. It simply says he's in charge of it. 2, there is no evidence before this court that there were any vessels to market or sell that Mr. Ivankovic failed to do. Indeed, it wasn't even put to Mr. Ivankovic that he failed to market and sell vessels, so perhaps this case has actually been abandoned. And then 3, how could Mr. Ivankovic market and sell on behalf of KJI when he's not been appointed a director? I mean, how, for instance, could he commit KJI to a sale contract selling a vessel when he's not a director of KJI? So there's that breach, which is the only breach that's asserted that, as I say, isn't relied on for termination. But in my submission, that case is bad. If Your Honour does find a breach, then Your Honour will have to consider the question of relief, and it's put on 2 grounds. The first, KJM seeks a sum of money. Now, the only pleaded case, and this is at page 548 in the bundle. This is the defence and counterclaim. You can see here there's a little table setting out the obligation and the payments. And you see the only payment he hasn't made, it is said, is that 873,974. Do you see that next to the August 2024? And that's why it's said that the balance outstanding is just $238,000. So the only sum of money that it is alleged that Mr. Ivankovic owes either to KJN or to KJI is that $238,000. That's the renewal of the factory license and the lease. And I've already made my submissions about why he is not liable to pay that, because there was no agreement to pay it, and it requires an agreement. Now, my learned friend Skeleton bandies a whole series of other figures around. They're not pleaded, and therefore they're not open to them. And that's the simple answer to that. And then there's a loss of profit claim. And KJM, I think, candidly accepts that there's been no disclosure, there's no evidence, it hasn't got a case. And so I think what's asked for is some process after this trial to try and determine what the loss of profit actually is. That, in my submission, is not an appropriate way to proceed. A claimant, and for the purpose of this counterclaim, KJM is a claimant, cannot just turn up at trial and say, well, I haven't got any evidence, I haven't put my case together, so can I have another go, please? If KJM actually wanted to advance a loss of profit case, it had to do so at this trial, or seek a direction well in advance for a split trial, and it hasn't done that. But as I say, Your Honour doesn't really get to any of this because there are no breaches that have been established. That, Your Honour, I think brings me very neatly to the agreed time for lunch at 10:30 in the UK. Unless Your Honour has any questions for me that are usefully dealt with now. Your Honour might have questions for both of us that you want to pose at the end of closing. I'm sort of entirely in Your Honour's hands.
No, I have nothing at the moment. What I'm minded to do, unless there's any great objection, is take a slightly shorter lunch today, because we don't have witnesses. So I was wondering if we could take 45 minutes and resume then at 2:15 Dubai time. Are there any reasons that's not practicable on either side? You just want to check with your teams.
We are content with that.
Okay, well let's resume then at 2:15
And
Dubai, 11:15.
Sorry, Your
London.
Honour, just before we break, I should just have clarified what I meant to say at the outset of the hearing, which is that I anticipate I'll only need 10 to 15 minutes, if that, by way of reply.
Okay, but anyway, let's keep disciplined on it. So okay, 11:15 UK, 2:15 Dubai.
I'm great.
Thank you very much. Okay, ready to proceed?
Yes. Your Honour, what I propose to do in my closings is to look at the construction of the loan agreement first. Then we'll come on to clause 2B itself and the Braganza duty that sits in with that. Then we look at the question of breach. Then we look at the factual question about receipt of the survey. Next, waiver, and then the repayment issue, deposit and counterclaim, and then finally the JV claim. And I think just as with Mr. Watson, I propose to spend probably 2/3 or so of my time on the Contessa claim, and then some of the factual material which emerges there follows through into the JV claim, which we can deal with relatively briefly. So before we then stick into the loan agreement, the headline position from my client is and remains that Mr. Ivankovich overextended himself and ran out of money. And that's why both claims have come before this court. It's not in reality down to any deficiency in the survey or any other procedural failing. And the absence of cash is why the Aquila balance was never paid. And the absence of cash is why the joint venture was starved of funds and has now collapsed. Mr. Ivankovich has presented himself to the court as a man with bottomless resources, but that simply doesn't ring true with the contemporaneous documents. We can look just at 3 or 4 quick examples before we get into detail of this. The first is page 1201 of the bundle. And this is an email we looked at a number of times in Mr. Ivankovich's evidence. Your Honour may recall the bottom bullet point there is Mr. Ivankovich saying that a negative delta in his liquidity has been created by the absence of sale in the Sunseeker. So what that means in layman's terms is that he, through his family's companies, had overextended himself with a Sunseeker. That had not sold. There was $11.5 million out. The fact that payment was in cash perhaps reinforces the point rather than undermines it. And they simply didn't have the free cash available to start making these other investments. So everything else was on a go slow, pending a profitable sale of the Sunseeker. We learned that it was marketed intensively through the autumn and winter of 2023, and that offers weren't received, which met Mr. Ivankovich's satisfaction. That's all that matters for him. But the effect of that was that there was no free cash available to comply with his contractual obligations through to KJM. We've also seen in the divorce proceedings, in the Chapter 11 proceedings, that there have been mounting financial difficulties for Mr. Ivankovich as well, leading to a contempt finding. That's at page 1097 of the bundle, and a warrant for his arrest at 1099. And indeed, I understood Mr. Ivankovich to be saying in his evidence that the money was not paid to purge that contempt. It simply elapsed as a matter of through the passage of time. We also know that the divorce proceedings triggered the Chapter 11 insolvency. and that was a finding of fact made in perhaps the one clear statement one can read from the bankruptcy judgment at page 1665 in the little footnote at the bottom of that page. There is no doubt that rulings in the Illinois divorce proceedings precipitated these bankruptcy filings. And in a sense, the ploy of the Chapter 11 bankruptcy didn't work because Janetta Vankovich's interests are preserved through the bankruptcy process as well. But one can see there from this comment that this is why there had been an objection to it. She was one of the objecting creditors, as I understand it. So it's those factors, rather than an unsatisfactory survey or any lack of transparency, that triggered the event which, in fact, follows. Now, turning on then to the loan agreement itself, and I couldn't help but note with interest that Mr. Watson's original structure in his opening dealt with the construction of contracts at a different point to his closings. In his closing, he comes to it last. And with respect, I can well understand that, because the structure of the contract is something which does not help him, and it helps my clients in a number of different ways. So, of course, one approaches the construction of a contract through the well-known authorities of Wood and Capita, and the court won't even be reminding of all of those principles. The point I made in opening is that though styled as a loan, it has the architecture of a profit-sharing commercial venture, and that architecture that informs Clause 2B. So what I invite Your Honour to do is just walk with me through the contract itself, and we'll look at some key points within it. I should say, excuse me, that the bundle references page 255.
I'm on 904.
Oh, sorry, yes. I've reverted back to my original markup. 904, yes. So 904, clause 1 records that the purpose of the loan is to be used for the purchase of the vessel from Sino Eagle Yachts, Inc. It's a named vessel that we see at the preamble. And the specifications are set out in Exhibit A. At the end of clause 1 there, we have a direct reference to Mr. Ivankovich. It's saying that the purchase of the vessel will be for and on behalf of Stephen Ivankovich, aka Contessa. And the structure was for KJM to be the purchaser and then to be the retailer and to sell it onwards, with Contessa effectively being the financier. The proceeds of sale, we can skip ahead to that point and then come back, are dealt with at clause 7b, with a top slice of Contessa receiving its cash back, and then a profit sharing agreement of 60/40. So we also have back at clause 3 of the contract an express statement that this is to be an interest-free loan. Now, there is nothing in the contract itself dealing with interest in the event that the vessel isn't purchased, but on a proper construction, I say, of the contract, we can deal with the interest points very quickly, that this was an interest-free loan, and the only route for a commercial return for Contessa was that the vessel would be purchased and sold onwards for a profit. It doesn't have a backstop of treating this money as a simple debt that is accruing interest. So we have an interest-free loan repayable on this commercial basis, where the parties share the upside 60/40 in Contessa's favour. And the risk allocation is made clear through the structure of loan of clause 2. The basic concept is that the 1.6 million has already been paid over by the date that this contract has been signed. And that is a sunk cost, not intended, unless it's KJM that decides not to proceed with the purchase of the vessel. The payment of the 1.6 million is not linked in any way to the survey report, nor is a refund of the 1.6 million linked in any way to the survey report. As I say, we know that payment predates the contract, it predates the survey, and there is no pleaded case, nor any case put forward in argument, that an implied term should be read into clause 2b, requiring KGM to commission a survey within a reasonable period of time, present this to Contessa, and to do any other steps linked to 2b, that would then mean that there is an obligation to repay the loan if some clauses of 2b are not satisfied. Instead, what happens through 2b is the obligation on Contessa to pay over the balance arises as part of a 3-stage process. The first is when a survey is provided. So it's clearly open to Contessa to say that the survey isn't required, but this is about Contessa's contractual obligation to pay over the balance under the terms of the contract as originally written. So KGM has to provide a survey. Contessa then decides whether or not it's a satisfactory report. And Contessa then pays over the money within 5 days of receiving the report, if it is satisfactory. Now, plainly, within clause 2b, the parties contemplated a possibility that KJM would hand over an unsatisfactory report. If that happens, Contessa is then under no obligation to pay over the balance of the money, and KJM, for its part, has denied the prospect of, first of all, recovering its expenses, and secondly, denied the prospect of earning a profit. So Contessa is given the option of walking away at that point, but there's no obligation on KJM in this scenario to return the 1.6 million. And if the parties had wanted to impose an obligation on KGM to return the 1.6 million in the event that an unsatisfactory survey was provided, then the parties readily could have inserted relevant language in clauses 4 or clause 7. And indeed, we can contrast that with what is
happens
it?
to the 1.6 million?
So the 1.6 million is a sunk cost.
I'm sorry, what did you say?
It is a sunk cost. It is not refundable. So
even though it's a loan?
Well, it's a loan because it's only repayable in the event there's an onward sale. So it's repayable in accordance with clause 7 of the contract.
But what about clause 5?
Well, so if I may, I'll start at clause 4.
Okay.
Because clause 5, I say, is all about a decision being taken by KJF. It doesn't deal with what happens if an unsatisfactory report is provided.
So you've got an unsatisfactory report which absolves Contessa of paying the 2.39 million. and Contessa is then entitled to walk away, and it loses 1.6 million.
Yes, it loses the money.
That's the commercial reality of this contract on your submission.
It is both the commercial reality and the proper meaning and effect of the contract.
Okay, and so you've got a vessel which is unsatisfactory.
According to the discretionary powers exercised.
Well, let's take an extreme example. Let's say it really was unsatisfactory. Let's say it was an appalling condition. So Contessa justifiably, in the exercise of its discretion, says, "Oof, I'm not buying that." And no arguments about the reasonableness of its decision or otherwise. The reality of this is it still loses 1.6 million, even though the builder has produced a wholly unsatisfactory vessel.
The reason why that is a conclusion is because we have an upstream relationship between KJM and Sino Eagle. So we have, as between KJM and Contessa, they have an aligned interest. Their aligned interest is to sell the vessel onwards for a profit, or i.e. for more than 3.99 million. The decision-making power as to who purchases the vessel sits with KJM alone. So it's the part, and that's because it's a party who has to face the burden of doing the work to sell the vessel. And it won't get paid unless it will sell the vessel for more than 3.99 million. And indeed, we've learned from Mr. Ivankovich and his evidence that the sales market can be fickle. He's talked about post-COVID softening of the market and the efforts they took to sell the Sunseeker, which didn't work. So
let's go back to our example. So
well,
let's say it was reasonable to reject the survey report, and so then Contessa, you say, loses its 1.6 million. So who gets to keep the 1.6 million?
Well, this is not a tripartite contract. So as between Contessa and KJM, the 1.6 million sits with KJM. I can't go beyond that because that's what happens in this contract.
So essentially, Contessa gets to keep the 1.6 million because there is an unsatisfactory vessel. Okay, that's the submissions.
Well, sorry, you said Contessa there. It's
not Contessa. KJM gets to keep the 1.6 million because the vessel's unsatisfactory.
Well, no. So I don't. Clearly, I'm not saying that, am I? Part of the allocation of it's all about the allocation of risk in this contract. So the allocation of risk for the 1.6 million sits with Contessa. It has paid the money over without any written terms and without any obligation on it to right to have that repaid. When it says
the money is loaned, that's not true.
It's not. Well, I'm not saying it's not true, but the character of this loan is in fact different. The character of this loan is it's a joint commercial venture in miniature, whereby Contessa puts up the capital and KGM puts up the sweat equity to sell the vessel. So if one thinks of it as closer in structure to an equity investment.
So it's called a loan.
But it's called a loan, but we can see how
repayment provisions.
Well, the repayment provisions are in many ways no different to the repayment provisions we then see ultimately in the joint venture agreement, because there had been a loan to the company, so one has your capital being paid back as the first bit of profit, and then you have the distribution of profits afterwards.
Okay. So the bottom line is, commercially, if the vessel is genuinely unsatisfactory, then you say that Contessa loses its 1.6 million,
So I say
even
yes.
even if that money has not been paid over to the boatyard.
Well,
You have to say, I thought you said you conceded that a moment ago, because it is not a tripartite contract.
it's not a tripartite contract, though it would be a different type of claim against me if there really was an. And sorry, I should say perhaps Mr. Watson could refrain from engaging visually during my submissions. I believe I did. The
Well,
same
that's
for him.
all right. I'm looking at you, so I didn't even see him.
Okay. This is not a fraud claim against my client. This is not an allegation that we took the money and ran away with it. The starting point is, as in the preamble to the contract, that this is all about the purchase of a vessel from a manufacturer.
Yes.
And I'm not able to help Your Honour on the precise terms of the upstream relationship, that we do have more than sufficient material to show that there was an upstream relationship, and that it's not a case of KGM pocketing the money, because in fact we have, indeed we have bank statements showing what happened to the money, and all of that predates this contract. So the commercial reality of who receives the 1.6 million as a sunk cost is it's Sino Eagle. And that will be, and it's the whole nature, in effect, of a deposit. It's a deposit which is forfeited if ultimately the vessel is the completion vessel does not happen.
If that's what the contract between Sino Eagle and your client said.
Well,
which we don't know.
What we do have as part of the context of all of this is, as at the date this was signed, part of the factual background is that we have the Volvo Penta report show it, and everyone knows this is a new vessel sitting in the Sino Eagle yard. This is a vessel where a survey has already been commissioned, and Sino Eagle is facilitating that survey. And we know that 7-8 months earlier, it was found to be in full mechanical working order. So that is the context of all of this, that there clearly is a vessel being purchased that is clearly being held out by the manufacturer as being ready for delivery, or certainly ready to be surveyed, put it that way. It's not sitting in bits and pieces sprayed across a yard. It's not sitting at the bottom of the harbour. So one doesn't.
I think Mr. Ivankovich's suggestion that there never was a vessel is not credible.
Yes, and indeed, if that was a claim being made against me, this would be a different sort of claim. This would be a fraud claim, and it's not that. This is a contractual claim linked to the proper meaning and effect of how does Clause 2B operate, and whether or not Contessa has rights for repayment under Clause 5. So
what I'm not persuaded about is that any more than on a balance of probabilities $1 million was paid in relation to the vessel. Well, the bank statements don't show a 600,000 payment. They show various payments as low as $907. You've got a continuing relationship as a dealer with the boatyard. Those could be payments in respect of anything. I mean, I would be more persuaded if I saw a single payment of $600,000, which I don't.
You do see something very close to that indeed.
Very close is not the same.
Well, $587,000 is effectively $600,000 once one takes into
I mean, if you had
potential
any
movement in foreign exchange.
Any documents, your payment schedule or receipts from the boatyard, that would be fine. But I'm in an area where I'm going to have to make inferences from the absence of documentation.
Well, I'm certainly not here to argue with you. I'm here to put forward my client's case. To
of course, you're here to put forward your client's case, and I'm giving you an opportunity to let you know where my mind is.
Of course, and I will come to some of the payments in due course. So
yeah.
If we focus just for the moment on the contract, let me just and explain why I say that this result aligns with commercial common sense. So
Yes.
5 quick points. First, this is a commercial venture with an intention to make a profit only following onward sale. Second, that the parties had aligned interests, where they both stood to make a gain only if the vessel was sold for more than 3.99 million. Third, the contract allocates KJM as the party who is the decision-making party to decide whether or not to proceed with a purchase. Fourth, that decision-making power is to be taken with the knowledge that Contessa could exercise a veto over any onward sale. And we see that in clause 4C, that any onward sale must be approved in writing by Contessa prior to finalisation of the sale. So KGM was leaving itself open to having effectively an ongoing liability to carry on marketing and putting in its efforts to sell this vessel until Contessa was satisfied that its return would be high enough. And with those 4 factors in mind, there is no reason to believe that KGM would take the decision to proceed lightly. By contrast, there's every reason to think that Contessa had already committed to providing the money, so long as KGM wished to proceed with the purchase, and Contessa's fallback position was committing only 1/3 of the money if it wished to pull out after having seen the survey. Now, a point raised in Your Honour's comments in the course of Malone Friend submissions was whether or not you have to make a finding of fact about the contract for sale for the vessel itself. I recorded Your Honour to say I must make a finding of fact over whether there was a contract for sale, and indeed Malone Friend entirely properly didn't support Your Honour in that suggestion. The reason for that is that in fact it's not an issue between the parties as to whether or not there was a contract for sale of the vessel. The list of issues at page 5 of the bundle it's a document which starts at page 4. Then we have the list of issues.
Draft agreed list of issues and common ground.
Yes.
And those, so this is not a draft, this is agreed.
This is agreed, yes. And the word draft wasn't deleted after the parties had agreed it. So the list of issues is then set out from page 6 onwards.
Page 6, okay. Okay, where do you want to take me?
Well, excuse me. So the list of issues there and over the page does not include an issue as to whether or not there was an upstream contract between the parties. Indeed,
but I have to make findings of fact.
Well, Your Honour, nobody. So
and I mean, I can't be I can be bound by what the parties agree to be common ground, I suppose.
If I put it this way, most neutrally, nobody disagrees that there was a contract to purchase a vessel. What we do not have, and indeed no party, I think, puts a positive case based on the evidence that Mr. Watson might have seen, is the price paid for the vessel by KJM.
Okay.
So what we do have in terms of just showing evidence that there was a contract for the vessel, I'll just take your honour through that quickly. For your notes, if you note page 925, 1973 and 1282, we'll then just quickly walk through that, and that I hope does close off this point as to whether or not there was any proper relationship with Sino Eagle. So 925, first of all. So this then is a communication from 30th of May 2023 between Aquila Boats and Sino Eagle. This is, you see the subject line, Aquila 70 order confirmation. And everyone's excited, looking forward to welcoming you to the shipyard.
Sorry, 923. I was looking at 925. I'm so sorry. 923.
So it's 925 is as 925 and 926 is this particular exchange.
So you see on 925, thank you for sending the signed documents and proof of payment transfer. So there exist signed documents and proof of payment transfer which have not been disclosed. What am I to take from that?
Well, you want to, all I can ask you to see from this contract, from this email, is that there was a contract for sale for the vessel, that as between KGM and Sino Eagle. This is not a mirage being put together by.
No, I accept you have to be very careful in making inferences.
So that's what I take from this. And we have that over the page at 926 as well. We have a reference to the addendum.
Now, I'm told that the addendum doesn't relate to this transaction at all.
And Your Honour was taken to the email from Pinson Masons confirming that they looked at the addendum, and it was, so the lawyers have seen it, and Pinson Masons concluded that it's not relevant.
Well, one of the inferences from that, because I clearly accept Pinson Mason's judgment, is that the $1 million doesn't relate to this transaction.
Well,
we are pleased to enclose the signed addendum together with the transfer document of the sum of 1 million. So if the 1 million is linked to the signed addendum, and your solicitors, whose word I accept without hesitation, says that the signed addendum has nothing to do with this transaction, then the implication is the $1 million has nothing to do with this transaction either. I mean, you can't have it both ways, it seems to me.
So, read as a whole, that sentence refers to the sum of $1 million advance payment against the Aquila 70 as promised. So one has to read.
Well, sorry, where do I see that? It says Aquila 70 order confirmation at the top. Yes, okay.
Yes. 926. So the sentence itself links the $1 million to the Aquila 70.
Yes.
So we have that. We have 1973.
It's very strange. Yes, okay, 926. And I assume the addendum is an addendum to the master. So we finally, in Mr. Hyderabad-Waller's evidence, learned that there was a master agreement between KJM and Sino Eagle, which would make sense why an addendum was signed in relation to an individual sale.
Logically speaking, yes.
Yes. But that addendum has nothing to do with this transaction. Okay.
So what appears to be happening in this exchange is there are two things going on. We have talk of the addendum and talk of the Aquila 70. We then get further discussion of the...
you just look at the wording. We are pleased to enclose the signed addendum together with the Well, anyway, it says what it says.
Yes.
But I find it extraordinary that the signed addendum has nothing to do with the Aquila 17.
Well, Your Honour, there we have it. We then move on to 1973. And the relevant email is at 1974 over the page, because this is an email between Aquila Boats and KJM.
Yes.
So this is a year later, and it's a clear statement by Aquila itself. So we will consider the paid deposit as a total loss.
According to our purchase agreement. Yes.
And then that email is forwarded on to, or perhaps it's the, I don't know whether it's the email or the letter attached to that email is forwarded on from Mr. Radwan to Mr. Moore, and that's on 1973. So again, I take from this the straightforward conclusion that there was a contract to purchase a vessel from Sino Eagle, but Sino Eagle is putting forward a statement that unless you pay the balance, you will lose the deposit. So it's not about KJM receiving a windfall. It's Aquila forfeiting the deposit.
But Sino Eagle have not anywhere have they acknowledged, or we don't have receipt for the amount paid to them.
Well, we have acknowledgement of the $1 million.
Where's that?
So that was just where we saw that at 925.
925.
Yes.
Yes. Oh, quite. Okay. We have an acknowledgement of a payment of $1 million. Yes. And it's headed Aquila 70. Yes. Okay.
Yes.
Okay. Yes, you're absolutely right.
So, happy I can answer some questions to your honour's satisfaction. Then the final exchange on this is 1282 to 1284. And this is effectively a continuous. So in fact, we start at 1284. That is one of the emails we've just seen at 1973, but we then get different emails further up the chain. 1283. So reply there from Mr. Al-Jazmi.
1282. Reference again to within the terms and conditions of our sale agreement. Yes. Then 1283.
Well, and then you want to, if I may, it's that next paragraph which says, therefore, the entire deposit received from the dealership is lost.
Yes.
And the boat will be sold via the dealership network. So we now have a statement that's on the 9th of August on 1282 that Sino Eagle has forfeited the money.
Yes.
So coming back to my construction argument, this is not about KJM receiving a windfall of the 1.6 million, having handed over a survey of an unsatisfactory survey.
But they could have a windfall of 0.6 million.
So I'm not able to help you on what else it is. I am able to show you that and what I do ask Your Honour to infer is that these subsequent payments, amounted to about 800,000, are linked to this vessel. I've heard what Your Honour has said already about that. I don't have any more material to show you beyond the bank statements themselves. No. But I ask you to make that the inference in my client's favour.
Yes, I understand.
And this is all linked to the proper construction of clause 2B.
Yes.
And of course, everyone accepts that that the parties may have different views about whether or not the the survey is satisfactory,
Yes.
whether or not one is talking about it as a survey as a process or survey in terms of satisfactory of the conclusion of the condition of the vessel. And it's because the contract allows a difference of opinion that the contract also provides for Contessa to forfeit its 1.6 million if it exercises its discretion. And it is, I say, important for the court to bear in mind in its analysis of the contract and the claim itself that it is not said we committed any breach of contract linked to clause 2B at all. It's simply
But I mean,
said,
you're saying as a matter of construction, bottom line of all of this, as you say, is even if Contessa exercises its right to reject the vessel on entirely proper grounds, it forfeits its 1.6 million.
so,
Bottom line.
and it's precisely that if Contessa decides that within its discretionary powers, this is not a satisfactory survey, then it loses 1.6.
Yes, I mean, even if it's quite rational in doing so.
Yes, because that is a consequence of the bargain it has entered into.
Okay, so it's an ill-advised bargain, but you say that you remind me of the English authorities. It's not for the court to rewrite bad bargains, etc., etc.
And I don't say it's an ill-advised bargain. I say it's just simply the bargain that the parties picked, and it's all linked to. Well, I'll perhaps come on to the survey itself shortly, but let's deal with the Braganza duty briefly. I don't think you're needs much help with me about from me about whether or not a Braganza duty.
No, I think I've heard everything. I've heard everything that Mr. Watson has said, and I'm unpersuaded that there isn't a duty.
Thank you. Well, I don't think Mr. Watson and I are expecting an extempore judgment at the end of today, but I shall take that and move on. I think let me just check my notes if there's anything else I want to say along the way. Yes, just a little point to make then in terms of the clause 2B itself. This is all about an evaluative exercise being made by Contessa. And that is directed to an identifiable object, namely the adequacy of the survey, and is able to take a step that would prejudice KJM, because if it withholds the money, then KJM doesn't get paid, and that will become even more so if it has a right to do so, to withhold the money, and then KJM comes under a positive obligation to repay it. So, Your Honour we've talked about the extreme example one way of this being a scuttled vessel that is then a survey is put forward. They hear the survey and that's it. But the other way round is that we have heard in the evidence that vessels, it would be worrying for a survey not to contain a snag list after a 5-day process. And this clause talks about a survey. It doesn't talk about a survey plus follow-up surveys. This is all about a 5-day window following presentation of a document and then a decision being taken. And if Contessa takes its decision not to pay over the money due to a toilet not being sufficiently washed, let's put it down to that extreme, that would be rankly unfair on my client to be faced then with a burden of repaying the $1.6 million for the want of a loo brush. So I say that the Braganza duty then flags up why it is that we have the contract working as it does. So if one takes the clause at its face and assumes that there is a Braganza duty involved, the next question is whether or not Contessa's determination that the report was not satisfactory was rational. And clearly I don't get there if Mr. Watson succeeds in the end on his primary case, that rationality doesn't come into it. So my primary argument in terms of rationality is that we are looking at the report as a document, not the conclusions relating to the vessel.
The threshold question of fact in relation to rationality is when the report was handed over, because your expert agrees that if it was handed over a year afterwards, then that's not satisfactory. So you firstly have to establish when it was handed over. If it was handed over roughly contemporaneously with when it was made, then we look at the rationality of
it. Yes, and I come to it perhaps the other way around, but we end up at the same location, that everyone is happy with this report, both as a report and its views about the vessel. That there is some argument at the margin about who should do the air conditioning works before it comes through, and whether that requires further investigation. One at that point is in a paradigmatic. So let's deal first of all with the process points. Everyone is content that this is a proper survey. We can then move on to the conclusions question. That there is to an extent, a live debate between the parties about whether or not this report says it amounts to the vessel being ready for delivery the next day, or whether some works would be required. None of that quite locks in to what the contract says. It's about whether or not this is a satisfactory survey. So it would be entirely open for Contessa to say this is a satisfactory survey. We would like everything else to be sorted, and then it's down to KJM as part of its decision-making powers to then go off to Sino Eagle and say, right, we've now got the money, but we'll tell you what, you've really got to sort out these these snagging issues. And again, everyone has agreed that part of the process of concluding a sale is this snag resolution process. And we have both key witnesses talking about this in their evidence. So Mr. Ivankovich talks about the analogy of riding a horse before you buy it. Mr. Al-Jazmi has talked about, he gave an example of a vessel in the Maldives being delivered, and again, people flying around the world as part of all of that process. So clearly, the purchaser of the vessel never simply gets a survey and then says, right, on the basis of this piece of paper, I'm happy with it. But instead, what happens in this contract is that all of those peripheral aspects, and indeed perhaps very important to the party aspects of who goes and has a look at the vessel and a bit of a test ride on it, all of that falls to KGM as part of its decision-making power whether or not to proceed with a purchase. Contessa's contractual rights are limited to the survey itself. And the survey itself is only ever going to provide a report on the condition of the vessel. No surveyor in the property world, or I imagine any other world, is going to take rationally would take it upon him or herself to start giving a professional recommendation whether or not to buy the asset in question. That's not the purpose of a survey, and that commercial decision, I say, was all for KGM to take. So, on the question of whether or not the duty was breached, we have dealing with the survey itself. We then have the threshold point about when was it handed over, and Your Honour here has a clear blue sky of about 1 year period between the two parties on this. We say July 2023. Mr. Watson's client says 11th of July 2024. The chronology favours me, but before jumping into the detail of it, we can make a few quick headline points. We know that everybody was involved in commissioning the survey, and that took place in May and June 2023. We know that after the survey was carried out, that there were a series of in-person meetings in Dubai in July and August 2024. We know that by September onwards, 2023, the parties are talking about an onward sale of the vessel. And in the course of those discussions, Mr. Ivankovich makes a series of promises about making payments. And at no point does he mention the lack of a survey. And finally, in terms of headline points, there are no reasons for KJM to be coy about the report. It commissioned the report openly and had every reason to provide the report to Mr. Ivankovich. Because indeed, the provision of the report was the key to unlocking the balancing payment. So there are then a number of different dates to walk through. I'm content to do it as fast or as slowly as your honour would like, but you'll have seen all of these documents previously in the course of evidence.
Yes. No, I mean, I have to say that your last point there is probably your best in many ways, because why wouldn't your clients disclose the report? There seems to be no rational reason not to.
Yes, and it's in everyone's interest that certainly we know by the end of this chronology that Sino Eagle is pressing for payment, and if there was any issue about have documents been provided or not, that would have been discussed, and it would have, KJM would have sent it onwards. Matters changed slightly come April 2024, by which point the parties' relationship is breaking down. But even then, we have an open offer by KGM for offices, visits to happen to their offices. And we're told that's not an onerous request, because that's happening all the time by all sorts of different people from the Ivankovich world, put it that way. So you want to, perhaps if I just read out a few key dates and page references, and then you can slow me down when you consider appropriate. So we have the May dialogue, and it's now common ground that there's a Zoom call that happened in May, not June. Then we pick up the story 13th of June, and in the May dialogue, it was Mr. Hand who was going to be visiting the yard. And that's not a contractual right that Contessa has, but indeed that's a pre-contractual discussion as part of what they were talking about at that time.
You give me the page references too. It just helps my note if you've got them.
Yes, let me do that. That'll be in the WhatsApp. So if we start at the reference from Mr. Hand. Page is 899 and 900. So that's the letter of invitation. Then we have the quotation from Admiral Marine at page 910. And that's the 9th of June. And what I'll do for now, I'll give you date and then page reference. Next date, 13th of June 23, page 918. This is an email from KJM to Mr. Hand. I'm here, everyone talking about time is of the essence, and the importance of getting everything sorted quickly. and Mr. Hand at the top of the page approving the appointment of a surveyor and saying time is of the essence, the boat needs to get to Dubai as soon as possible. And then the email chain from the 13th of June to the 22nd of June is at pages 922 to 923. And that there is the confirmation by KGM that the surveyor has been appointed and is going to be visiting after 3rd of July, or from 3rd of July onwards. Then we have Mr. Al-Jazmi's evidence at page 96, paragraph 45 of his witness statement, where he gives the dates of the meetings in July 2023. And these have all been accepted by Mr. Ivankovich as accurate. And my case is that the document was handed over at one of these meetings. We then know from both parties that there are regular meetings at the site. We don't have all the dates of those meetings, but we do get some snippets in the documents. There was a meeting on the 23rd of August, 2023, page 1095. And already at this time, we talk about the onward sale, no reference to the survey. This note is being prepared, of course, by Mr. Hand. And if there had been a question mark about where is a survey, you told us 2 months ago this all been commissioned, what's happened, one would expect to see it here, but we don't have that. A month later, we have another exchange page. As a date is 29th of September 2023, page 1106. And so on 29th of September, talking about structuring for the onward lease of the vessel. And then on the 5th of October, page 1108, Mr. Ivankovich is having already sent a spreadsheet. He's then talking about the bet we are making. That's the bet he's making with the vessel. Page 1121 is an exchange in later October. This is an email as per your request. And at this point, I'd ask Your Honour to prefer Mr. Perush's evidence to that of Mr. Ivankovich. That the reason that email starts with as per your request is that Mr. Ivankovich had asked to be reminded of payment of the balance amount. They're talking about making a balancing payment. Nobody's concerned about the survey at all. And then over to page 1122. And this now is our reference in the contemporaneous documents to marketing efforts. And Mr. Ivankovich is agreeing with that. But at no point is he saying here in this exchange, hang on, the cart is getting before the horse. What about the survey? And that discussion then carries through. We have a number of pages here into a 1126, where there are screenshots of calculations. That's all linked to the vessel. And it's Mr. Ivankovic here at 1127, putting forward figures for what the sale price is that would be acceptable to him. Then 1144, it's the 14th of November 2023. And we have we start at 1144. And I say here that Mr. Ivankovic, his evidence should not be accepted, that they're being cheeky or sarcastic, as he puts it in his witness statement. He's making a promise to send them a wire. And frankly, whatever he thinks he's saying, his own subjective understanding of those words, Mr. Hybrid Waller understands the language to be to mean what it says. And hence his reply, we need the 70 in this region. Then over the page, 1145, this is Mr. Hybrid Waller pleading for the balancing payment of the Aquila 70. And there is a slight discontinuity here, because 1146 is not actually the next page in the chronology. That is a response which happens on I think the 4th of December. So we better carry it on at 1161. So we then flip into Mr. Ivankovic's WhatsApps, and we see there at the top of that page, 1161, that in fact, as far as the balance of the payments for the 70 Aquila, that message was sent a few days later on the 4th of December. But that is the time when he engages substantively with the message from the 30th of November. And the fact that the payment is already set up suggests that Mr. Ivankovic is satisfied that with the condition of the vessel. We then start to discover through March next year why all these promises have been empty promises. This is in the email of the 7th of March 2024 at page 1201. And this is the first time that Mr. Ivankovic complains about liquidity issues. And the response is significant as well from Mr. Al-Jazmi, page 1200. And if I can ask you just briefly now to read number, let me see, just the bottom of the page. If I ask the EP technician to scroll up, there we are, after the word Aquila at number 3. So, Your Honour, the importance of this communication is, to my knowledge, this is the first time that we have a contemporaneous communication to Mr. Ivankovic saying, unless you pay the balance, the manufacturer is going to take the deposit. And if Mr. Ivankovic had not seen the survey at that point, there would have been an electric response. But no point saying, how dare you? how dare Sino Eagle. What we have then is an exchange at the start of April. Page 1206. This is a page you made us that recall. It's very hard to read on a black background, but it's the first. Excuse me. It's the third bullet point. In effect, what Mr. Al-Jazmi is saying here is that your delay is causing us real problems with our relationship with Sunseeker. And then moving on now, 1250. We have Mr. Al-Jazmi now giving a precise date towards the bottom of that page. "28th of April 2024, with no responsibility on us if the factory revoked the transaction and took the deposit."
21st of April.
21st of April, yes. Now, the reply is at the top of that page, but it's only half of it. So the full version appears 1252. We just scroll down slightly, please. It's over, in fact, on 1253. Mr. Rankovich discusses the Aquila vessel. He's referring back there to document requests from Casey and Ollie about the Aquila purchase. And then Mr. Ivankovich is saying all of this is actually a loss for the JV. You see at the bottom of that paragraph, a loss of deposit will be a loss for the JV as specified under the JV documents. So there's no contemplation there that anyone's going to get a refund if the vessel isn't delivered. It's just simply a question of where the loss is suffered. And then rolling all the way forwards, it's the 26th of June 2024 on page 1973 that we then have, we've looked at this already, Mr. Radwan passing on the communication about the final payment deadline, 3rd of August. And then from that point onwards through July 2024 and the start of August 2024, the lawyers move into the foreground and the principals are in the background. Just a few key emails, page 1983. Mr. Radwan there saying, talking about the discretion that Mr. Ivankovich has through Contessa. Does he want to press forward or not? And that discussion matures by the 30th of July 2024, page 1296. And Your Honour will remember there are some emails along the way here, and indeed the email including the admitted fact that we have a digital receipt of the survey and some discussion about the survey. But then on the 30th of July 2024, We then have a request for the wire instructions, and a request then for the named purchaser now to be Mr. Ivankovich. So it's a different sort of contract that's being, a different sort of structure that's now being envisaged. But this scrapping around is all far too late. 2nd of August 2024. Indeed, I should say just on this document, Mr. Ivankovich now distances himself from that email, but I'm afraid the law agency doesn't work like that. But his lawyers wrote it, and he stuck to the consequence of it. 2nd of August 2024, page 1322. And just actually towards the top of that page and into 1321, it's here Mr. Moore confirming that Mr. Ivankovich does want to proceed. He wants to proceed on a different basis. He wants some of his own people to visit the yard. And that's all well and good, but that's not what the contract says. I'm afraid it's all too little, too late, and we've seen the correspondence from Sino Eagle already giving clear notice they would forfeit the deposit by then. So in terms of the witnesses on this point, both the key witnesses have been did not move in their evidence on the point. Mr. Ivankovich denied receiving a document in July 2023. Mr. Al-Jasmi was clear that he did give the document in July 2023. With respect, Mr. Ivankovich's credibility is somewhat undermined by now seeing ghosts behind every corner. He now goes so far as to suggest that the Admiral report was created artificially in July 2024. None of these are pleaded points. And indeed, it contradicts what his own expert is saying. And it just shows, as ever, in cases of this nature, that parties' emotions have rather clouded their proper recollection of events. Mr. Al-Jasmi's evidence was clear and fixed on this point, that he provided a document in July 2023. It's the key statement from him is day 3, page 55, line 1. Going to turn it up, but that's the transcript reference where he says the actual handover was in July only. And then Your Honour asked, did you personally give the report to Mr. Ivankovich? To which the answer was yes, I did. I delivered it to him in person. That's day 3, page 17 through to 18, and again page 35. And again, he said that he showed the report to Mr. Ivankovich again in February 2024. And that will be consistent with a hard copy being at the KGM offices. I don't seek to overstate Mr. Al-Jasmi's evidence. He was speaking through an interpreter, and some imperfections may well have emerged in his recollections, but he was clear and steadfast on this point, and I ask that his evidence is accepted on this point. So, if you're not with me on actual receipt and the waiver and estoppel arguments arise, perhaps I'll deal with those quickly, and then we might take our mid-morning break at that point. Excuse me. Well, now lunchtime break for those of us in London, but mid-afternoon break for anyway, the short break for those elsewhere in the world. Waiver and estoppel. So. We've already looked at the exchanges and the messages from between Mr. Hybrad-Waller and Mr. Ivankovich. The key messages I rely on are the 14th of November, where Mr. Ivankovich says we will have to send them a wire. Shall have it shipped to the US as well. The 4th of December, as far as balance of the payments go, it's already set up. And for the 7th of March, email explaining the delay. There's Dr. waiting on liquidation of certain securities. So individually and cumulatively, Mr. Rankovic was treating the balance as due and the survey issue as closed. He never says that once during that period that he'll only consider paying the money once he's had a satisfactory survey. He's simply saying that he will pay. And the thing which stands in the way of payment is money, not survey. The learned friend relies in his skeleton on the no oral modification clause at clause 15. That, with respect, doesn't help him in this case. In my opening, I already took you to paragraph 16 of that judgment, which I believe we have at just your page reference. It's 728 of the supplementary bundle. Towards the bottom of that page, Lord Sumption in that case couldn't be clearer that no oral modification clauses can be circumvented by the doctrines of estoppel, and it operates as a proper safeguard. The test is over the page at 729. There needs to be some words or conduct unequivocally representing that the variation was valid, notwithstanding its informality. So one isn't looking for a formal statement of I hereby waive my right to look at the survey. Instead, one looks at communications in their context. We have here WhatsApps, and the WhatsApps by Mr. Rankovic saying words to the effect of I will make payment. And then on reliance point, at that early date in the chronology, reliance is, I say, straightforward because it's the payments which were made onwards to Sino Eagle after that date. And these are listed both in my skeleton and my other friend's skeletons in terms of the payments made. We'll just look at them briefly. 1632. This is a trial bundle, 1632. And I start here rather than the earlier payments because, well, if we scroll up slightly, so clearly I can't rely on waiver for payments made before there was a promise to make payment. So one gets that from October onwards, and it's we have there a big payment of $27,000. You want to ask earlier about the $600,000. That payment is made the 13th of March 2024, page 1637. And it's 588527. So that is as close as one gets to $600,000. But there's a further payment a week or two later. It's 28,000. Excuse me. Yes, it's a week later. It's $28,900. And all of these have the reference Aquila. So I asked Your Honour to make a finding that those payments are linked to the Contessa loan agreement, and they're payments made by my client to keep the transaction alive, and that all locks in with the communications by Mr. Jasmy about Sino Eagle threatening to foreclose on it. So that deals, I hope, with waiver. In terms of the later payments, the later communications in July, to the extent that I don't think Mr. Watson seriously hopes to hold my feet to the fire too much with the pleading, because he said in opening that he was content to deal with it on the facts, and the witnesses were cross-examined on some of the earlier points. It's a fair enough point for him to make in closing, but I say in substance it doesn't help him. The court has the benefits of full argument and the full factual matrix on the earlier transactions. In terms of looking at the late July communications themselves, they're to be seen in the context of the earlier communications and in the light of those promises by Mr. Rankovich personally to make payments. That's what was really being said there. The reliance is linked back to what then happens with the yacht itself. So because we have a promise to make payment, KJM then itself doesn't take steps, and this money is lost. If there'd been quite a different communication in July, that Mr. Rankovich is out, now we've seen the report, not satisfactory, not prepared to go for it, then KGM would have had a month to take whatever steps it needs to take delivery of the vessel. But it was denied that opportunity through the words and conduct of Mr. Rankovich through his lawyers. I mean, you're on his hands. I could go on for another 5 minutes and finish off Contessa, and then we'll have a break. Or we can
Let's
break
go on.
now.
Let's. Why don't you finish Contessa? It sounds cleaner.
So if, contrary to the above, Contessa was not obliged to advance the balancing payment, claimants must still the claimant must still establish a contractual right for the return of the 1.6 million. Clause 5 of the contract is their only route for that. And as I've said already, that clause is engaged only where the purchase doesn't proceed as a result of KJM's decision-making powers. Contessa cannot invoke the non-occurrence of the purchase when that flows from its own failure to fund the balance that prevented the purchase of the vessel. And in my skeleton, I rely on the prevention principle. Party may not rely on the non-fulfillment of a condition which its own act has prevented. And here the deposit was lost to the yard, and we've seen that the yard did treat it as a total loss, and that was because Contessa withheld the balance. So again, it all, in a sense, one gets there either through the original construction of clause 2b or the interaction of clause 2b with clause 5. But we don't have an allegation of breach of contract up to this point in time against my client at all. It's not said, as part of my learned friend's pleaded case, that we've done anything wrong through to actually through to September 2024, because that's when they make the demand for repayment for the first time. And it said that that demand for repayment, we didn't comply with it, and that was the breach of contract. So on a proper analysis, clause 5 isn't engaged because of the prevention principle. Second on this point, clause 6 requires written notice, and I don't think I need to trouble you further on that. Just finally on interest, Learned Friend's draft order and his skeleton asked for interest starting 26th of May 2023. That's a date of payment. Now, clearly that can't be right, because it's not said we breached contract from 26th of May 2023. So the earliest possible date that interest might arise would be sometime after the demand for payment or repayment is made. So we're talking September, October 2024, and the interest claim itself clashes with the express words in the contract. This is an interest-free loan. This is not a case where Contessa has an option to have its money paid back with interest. Alternatively, it gets a stake in the vessel. It only gets a commercial return in the event the vessel is purchased and it's sold for a profit. In terms of counterclaim, that I can deal with, I hope, in a couple of sentences. I need to win on the question of was there a satisfactory report within the meaning of clause 2b. Second, I cannot win that argument through the estoppel route for the purpose of my counterclaim, because I've been using it as a sword, not a shield. So in fact, I must win, and the court must be satisfied I'm right on July 2023 being the delivery date. I also need to win on the Braganza argument as well, so that there was a breach here. If it's an absolute discretion, then Contessa was within its rights to withhold the money for whatever reason. So it's not automatic that if one party loses, the other one wins. That there are slightly different routes that I have to win by in order to actually succeed on my counterclaim. And if I do win through that route, the next question is quantum. I've set it out in my skeleton in some detail. Mr. Jasmine gives a figure of $400,000. We've got a pleading case of both loss of profit or wasted costs. The figures are in my skeleton. I think my learned friend accepts them in wasted costs. 200 odd thousand. It's, I think, 1.83 million, I think, is the total figure paid over. So if you want to be satisfied that the bank statements up on the screen in front of you do relate to the Aquila vessel, then at a minimum, our wasted costs would be 283,000. And the alternate route would be loss of profits based on the limited discussions that were had by the parties concerning the onward sale of the vessel. So, Your Honour, that's my case on the Contessa. I can then go on, I hope, deal with relatively briefly on the joint venture.
Okay, so we'll take a break now. We'll come back at 5 to the hour, please. Thank you. Okay, shall we proceed?
Really, yes. Moving on then to the JVA claim, we have 3 grounds to look at for termination. The first is insolvency. I'd like to start, if I may, with the JV agreement itself. The contract starts at page 881. Clause KA3 is at page 886. And within that clause, you'll see there are 3 different types of insolvency which are relevant here. The first is if any venturer makes an assignment for the benefit of creditors or petitions for appointment of a trustee or receiver of the venturer or of any substantial portion of the assets of that venturer. Then the next option is if any venturer commences any proceeding pursuant to any bankruptcy. Or 3, if any venturer is adjudicated bankrupt or insolvent. I rely on options A and B. So if a venturer making an assignment for a substantial portion of the assets of that venturer. alternatively commencing proceedings. And we see that through the Ivankovich family, Chapter 11, debt, page 1357, I think is a reference. So, no, that's not. I was thinking that wasn't right. It's going to be. I've lost that reference. Let me find it again. Excuse me, 1675 or thereabout, 1657 it might actually start on. So we saw here in evidence that one of the people who petitioned for the Chapter 11 bankruptcy is Mr. Ivankovich himself. Let me try and think about precise page reference within the judgment. Excuse me, yes, the judgment starts at page 1647. And there's reference there to Mr. Ivankovich's confirmation affidavit of 1648. What Mr. Ivankovich told us in evidence, day 2, page 162 through 163, is that I don't have any personal wealth. In reality, all his wealth is tied up in the various different family entities.
Where do I see Mr. Ivankovich as a personal petitioner? So
we see that it's not as a personal petitioner, as and I hope I didn't overstate my case there. It's that he issues a confirmation affidavit.
What is the function of a confirmation affidavit?
So we see. I'll pick up the story. It says over the page. So page 1648. To see the words voting certificate underlined.
Yes.
Just after those two words underlined, it then gives the confirmation
and upon
affidavit.
Confirmation affidavit of Stephen Ivankovich. Yes.
Yes. And then over the next page. So the purpose of that confirmation affidavit is filed in support of confirmation of the plan.
But a creditor can be in confirmation of the plan, can't they?
But Mr. Ivankovich accepts that he is, and this is all for linked to his divorce proceedings, and we saw that through 1657.
Yes, but does that actually make him a petitioner? It doesn't, does it? I don't understand enough about US bankruptcy practice, really, to be able to say. I mean, you may know more than me.
So you want to, all I'm able to do is point you through to the fact that this is an application effectively made by the debtors. The plan proponents are explained.
Well, it's made by the debtors are various companies, but
they're all.
And so then it appears that Mr. Ivankovich has filed some form of affidavit, the function of which I don't know.
So what we really discover from this document, so far as relevant to my case on termination, is that there are a series of debtors which include the two A&O family companies, and that's significant because they make a lot of the payments. for the joint venture. They are described at the top of page 1648 as plan proponents.
Yes.
And it's Mr. Ivankovich personally who is one of the people signing off on this document. And there's no question that he's the manager of these companies.
Yes.
And that he's closely involved in it, because we also know throughout his evidence he talked about he being the person who arranges for payments. He doesn't seek to stand on ceremony in how he describes himself in the mechanics of the payments in his witness statements.
Yes.
So we know that in reality, that as he says, he has no money to his name. All his money is structured through these complex arrangements. Those complex arrangements and corporate interests were themselves restructured, linked to his personal divorce.
Yes, I assumed that the restructuring was to shield his assets from his alimony payments. I know he was unsuccessful in that because his current, soon-to-be former wife was made an exception to this scheme.
Quite, Your Honour, yes. So I didn't need to quite go that far with my cross-examination of Mr. Ivankovich, and thought better of it. But it strikes me that that's a fair inference to draw. That
Well, we got that from the footnote, haven't we?
Precisely, yes, yeah. So it certainly, I'll put it this way: that if that was the intention of the Chapter 11 process, then it didn't work, because the certainly the judge in Florida spotted this as a risk and protected Jeanette Ivankovich's interests. But nonetheless, the effect of that and the effect of the personal orders against him are sufficient, I say, to trigger the clauses K3 in the contract. And all of this is to be understood in the context of a warranty right at the front of the JV agreement, clause A, little b, that Mr. Ivankovich declares that he has the financial resources to provide the required capital for the funding of the fabrication, design, and manufacturing premium.
The page.
Excuse me, yes, of course, page 881.
881, yeah. Thank you.
So at 881, there's reference there to Mr. Ivankovich having the financial resources. Now, everyone knows in reality, it's not about him having the financial assets in his own legal name.
It's having access to them.
It's having access to them. And that is what is affected by the Chapter 11 process. And the wording of clause KA3 does not require the venturer himself or itself to be adjudicated bankrupt. It's good enough if it links into any substantial portion of the assets of the venturer. So that must then mean a company connected to the venturer in some way. And little b is if a venturer commences any proceeding pursuant to any bankruptcy. And we know that Mr. Ivankovich was one of the petitioners of the Chapter 11 process.
I'm sorry, I have to intervene there because that is simply factually false.
Yeah, I thought we'd been over that he wasn't a petitioner.
Yeah, and it says that the petitioners are the companies. So I think my learned friend has to be careful how he puts his case. It says
he is a manager of the companies that petitioned for Chapter 11 bankruptcy. That is the accurate record.
Yes, I would accept that, Your Honor. Apologies if I'm being insufficiently precise. As I hope I've made it entirely clear, but I'm not at any point saying that Mr. Ivankovich himself was petitioning for his own bankruptcy.
No, but
that would not be a real submission.
He is a manager of the petitioners.
Yes.
Whether that's enough for the purpose of the clause, I'll have to decide.
Fine. So all of that then is ground one. So the proceedings, so all of the joint venture money was, well, sent to either Glencoe or A&O. A&O is one of the Chapter 11 companies. And I say that therefore is met, that we have insolvency in one of the meanings under KA3. Ground two is non-payment. Now, this breaks down into two elements. First of all, non-payment of the Arrow vessels. Now, I don't seek to pursue that point because the personal attribution of the Arrow vessels is a matter that's been resolved by the onshore Dubai courts. The second aspect of that is late payments under the joint venture agreement and its amendments. And it's expressly admitted that the notice covers this, and that's at reply paragraph 36, page 563. In relation to JVA, sums due under the second amendment to the JVA, 36.1, said clause required by necessary implication written notice of exercise. The termination did give notice, did give written notice under KA1.
Sorry, paragraph
36.1 of Maloney Friends case. And the point taken against me is substantive rather than procedural.
Okay. So notice is missing. Mm-hmm.
So in terms of the joint venture amendment number 2, that is in page 913. And we have the first payment was made later in any view, comes after 19th of June. And then the second tranche is full due after the relevant build-up. Then we have the third tranche. Now the notice question that you asked another friend about of what notices were given for the capital calls.
Yes.
I rely on a notice of 24th of November 2023, page 1131. Oh no, that's hasn't come out right. It's an email of 24th of November 2023. Let me just find that.
Yes.
very sorry. Why is this not coming up? That's the old school way of looking at the index. There we go. Page 1137 is my inbound handwriting. So we have there express references to the addendum, the capital call table, talking about $1 million received and the shortfall from that, stating that the third capital call is due, asks for a precise amount. And so upon the construction of that email, it's asking the amount to be paid well in advance of the 1st of January 2024. The next document relied upon is in 9th of August 2024. That's at page 1349. This comes at a time when the process is more heavily lawyered. And here there's a request for payment of, this is an additional contribution by the 16th of August 2024. That's only second bullet point. So Mr. Ivankovic's answer about why he didn't make payments due for the original, in the original timeframes, being linked to the absence of a bank account for KJI, that I'm afraid doesn't ring true, because KJI has never had a bank account. So all of the payments which have been made have been to KJM. And indeed, when the contracts were signed, there was no condition precedent there that KJI would have a bank account or that payments would be made to KJI. On a proper construction of the contracts, it was simply requirement for payment by the dates given for the joint venture bank account. And that, for these purposes, the bank account held by KJM.
Just have a look at the financial statement.
The bank statement references are 116.
No, the financial statement.
Oh, yes, I referred that. I'm afraid we don't have that in the bundle. So what we get then is.
I thought we had the auditor's report, the financial statement.
But that comes later, so that's not this particular one being referenced there.
I'm sorry, I'm not following. I just wanted to have a look at the auditor's report.
The auditor's report is, of course, so I will show that to you. But this email is sent in August 2024. The auditor's report deals with the period finishing 31st of December 2024, which is why it doesn't.
It's a page 1702, is I think what you're on is 702.
1702 is where the audit report is, but then produced about 9 months later.
Yes, I just wanted to have a quick look at it.
Just over a year later.
Yes, bear with me a second. Yes. Why does it say cash and bank balances?
I'm not able to help you further beyond what it says in the audit report itself.
Yes. But I just wanted to test the suggestion that it never had a bank account. Well, either the audit report is defective in yet another particular, or it did have a bank account.
I believe we have evidence from the parties of the absence of a bank account.
I think if you want to look at page 1715 of the audit report,
1715.
it's broken down by the auditor as between cash in hand, cash at bank.
Cash at the bank to. So this is dirhams, isn't it? So yeah. So 261,000 dirham. But if the auditor were halfway competent, he would have seen a bank account. Is there a note? There's no note to suggest that KJM was providing banking facilities for KJI, is there? Okay. So anyway, this is unexplained.
Yes, well, so I'm not able to explain it more than it is in the evidence, and the payments by the ANO family trust to KJM.
Yes, it's just bizarre. Anyway, okay.
So we say that there should have been payments in time, that there was not payment, and that then was why there was a default. Ground 3 is material change under JB3. Again, this is expressly admitted as a ground covered by the notice. That's paragraph 35 of the learned friend's defence, excuse me, his reply, page 563. And it's 35.1. And the material change in the venture's management, business, assets, or company structure. We say, well, that's all covered by the Chapter 11 process. And also, that's where the divorce proceedings come squarely into focus as well. So on the liability points, that's all I have to say about those. On the question of relief, we do have a very substantial departure from the pleaded case in the draft order. And I don't propose to be overly forensic about it, but what I would invite you on to do after the hearing is to compare the declaration sought in the pleaded case with the draft order. For the moment, I think it's best just to focus my attention on the draft order itself, and to compare that with the terms of the joint venture agreement.
Yes.
Because clearly any rights, the maximal rights that Mr. Ivankovich might have are only those stated in the joint venture agreement. So the draft order is starts at page 41 of Malone Friend Skeleton.
Is there a reference to that in the supplemental bundle?
1075.
Thank you.
So paragraph 2 deals with the declaratory relief point, and I accept if I've lost on liability, well, clearly that declaration will be made against me. The problems come from paragraph 3 onwards. So we have here a proposal for specific performance or a positive injunction for the appointment of Baker Tilly UAE as the third defendant's auditor. We have no information at this stage about how its fees will be paid for. There's no promise to underwrite those fees by Mr. Ivankovich personally. There is no quotation of those fees, what it would now charge for those services. Nor is there any statement that Baker Tilly is willing to be appointed. So there are problems immediately with this proposal. And the direction for convening the General Assembly and voting for the appointment of Baker Tilly, all of this, I say, is overcooked. What the joint venture agreement does provide for is at page 885. No, we're in the wrong bundle. Sorry, this now should be the trial bundle.
I'm back in the trial bundle.
Oh no, sorry, it's the EP operator.
Oh yeah, I don't use that. Yes, I'm sorry.
Okay. So clause HC.
Yes.
Calls for a HC, little c.
HC, yes. Thank you.
Calls for a biannual audit in July and January, or June and December. So if my learned friend wants relief, declaratory relief, that the JVA entitles his client to a biannual audit, and then identifying the dates as either July and June or January, December, fine. But specific performance requiring specific votes takes us into a type of shareholder dispute which is simply not here. The appropriate route forward, if the court is against me on liability, will be to make a declaration that tracks through the appropriate words of the joint venture, and we then list the matter back for a consequentials hearing between the parties. If once these rights have been established and declared by the court, if they are to be declared, if the parties can't then agree how to put that into effect, then at that point, the matter will come back to the court.
Well, I just wonder if I would have jurisdiction above and beyond what is in the JVA.
And with respect to what that would be then an issue for a future date. So once we're talking about the steps being taken by KJI itself, which is an onshore Dubai company, we have.
We get into an area of conflict of laws.
Precisely, we do. And none of that has been properly argued before, Your Honour, today. There is the dispute resolution clause in the MOA itself refers to a final decision of the Dubai courts. Now, of course, it's settled law that the DIFC is a Dubai court, but I'm afraid the answer is not as facile as that, because one must, in fact, look at the contract as a whole and a proper interpretation of what this contract means in that wording. And this is an onshore Dubai company, and this is all about Federal Decree Law 32 of 2021 and the Commercial Contracts Law. So excuse me, the Commercial Companies Law.
I mean, even if one could, as a matter of construction, construe Dubai courts to include the DIFC courts, you still get into all of those sections of Dicey and Morris about foreign corporations that one would have to look at, I think.
Precisely. So certainly this is a point, given we're at 4:30 on a Friday, this becomes a very complex area once one is looking at the detail of the relief sought. So my brief submission in terms of declaratory relief, so if Your Honour is against me on the declaratory relief point, on liability of termination, then clearly paragraph 2 will be made against my client to effectively invalidate the termination letter. But then what follows from that should not happen at this stage. And if there is to be any further steps being taken by the court, it should be no greater than simply a restatement of the contractual language in the joint venture itself. And
yes,
this
so I could order that Mr. Ivankovich is appointed director.
So you could
I could give force to, assuming that I accepted that FA bound the parties, then I could enforce. I could specifically enforce FA1 that Mr. Ivankovich should be appointed as a director. Equally, I could enforce, if I were so minded, of course, HB, that he be given unlimited access to the books and records of the company.
Yes, so dealing with those 2 points briefly. So in terms of the appointment of Mr. Ivankovich, there is open to me to a certain extent a bit of a neat argument about the word initial director and whether in fact that's all been waived by the MOA. But I think for the purposes of 4:30 and a final, we can step on from that. If Your Honour is against me on liability, and if Your Honour is minded to take a step through the appointment of board director, then I can. I'm not here to concede anything on behalf of my client, but what one can see the court might then take the step of directing the appointment of Mr. Ivankovich. But the precise wording of that would need to be carefully done, and it would require specific argument. So, pausing here, all of this, I say, should be a matter for a standalone consequentials hearing once we know the factual position of termination, and we'd then come back for a half a day or a day in front of Your Honour and have a proper discussion about all of that. This is not the sort of relief that should be bolted on in a draft order that has contempt consequences flowing from my client.
Well, I can't see why it should have a penal notice on it in any event.
Well, so certainly, if there's be anything that looks like a mandatory injunction on my client to take a particular step, to for example, to vote in favour of the appointment of Mr. Ivankovich, then all of that should be done very carefully indeed. In terms of provision of document, as Your Honour points out, HB is what we see in the contract about the access that's had there, and that is materially different to what is said in the draft order. So the draft order at page 1077 requires procuring of electronic copies of all the documents that are in 1078. And this is incredibly wide-ranging. So we have bank statements showing the receipt and subsequent use of, excuse me, we're back in the supplemental bundle here for the EP operator and those following along. Subsequent use of the various different payments. I say that the correct order to be made at this stage is declaratory relief that Mr. Ivankovich has unlimited access to the books and records for the joint venture without cause. And that declaration in itself is unnecessary once the court makes a declaration that the joint venture agreement has not been terminated. So I say the gateways through which Your Honour should pass is, first of all, is he entitled to a declaration of the primary relief? Secondly, if he is entitled to that, should the court take any further step about any of these other details at all? And I say, no, it shouldn't. These are matters which flow on inside the joint venture agreement, and there's no utility for the court simply stating what the contract says. And then if the parties come back before the court to say there's been a breach of contract or something different, well, that's a matter that then happens at that point. But what should not be ordered now is specific performance of documentation of this type. And one looks at schedule paragraph 2, all bank statements for bank accounts in the name of the third defendant. On what possible basis would Mr. Watson's client have a right for that? Excuse me, that's third defendant, that's KJI, excuse me. So that
yes, he
would
does
be,
have a right.
He would for that. But the first and second defendants, he doesn't. And that's what flows through from paragraph 1. So if there's any order to be made, it would simply be restatements of the JVA itself. Your Honour, that concludes what I would like to say. I have been informed by WhatsApp message that Mr. Al-Jazmi would like to address the court very briefly himself as a director of the company. You're shaking your head, Your Honour, but perhaps you can articulate any reason do you have as to whether or not Mr. Jazmi has a right to do so?
No, he doesn't. He's represented by solicitors and counsel. If he wishes to instruct you to say anything, he can do.
Thank you. I've nothing further to say.
Thank you very much. Mr. Watson?
Your Honour, just a few short points in reply. Dealing first with the loan claim, and I should preface all of my reply by saying if Your Honour doesn't wish to hear me on a particular point, make it clear and I'll move on. But in relation to just the structure of the loan agreement, because my learned friend spent quite a bit of time there, and in my submission, his approach to the loan agreement is not correct. So we go back to it briefly at page 904. So clause 2, my learned friend sort of treads a fine line between saying this isn't a loan and it is a loan. So you have my case, it is a loan proper, capital L. Clause 2 defines the loaned money as the entirety of the 3.9 million. Clause 3 provides that the loan is without charge of interest. But that's subject to something which I'll come back to in a moment. And then the crucial fulcrum, if I can call it that, for the repayment provisions is condition 4A on page 904, which is that KJM will purchase the vessel. Because this is a loan in the sense that it always contemplates the repayment of everything that is advanced under it. It's just that the terms of the repayment depend upon this fulcrum of the purchasing of the vessel. In 4A, KJM purchases the vessel, and then the rest of the clauses in clause 4 follow, and you get to D, which is upon the sale, KJM repays to Contessa the amount paid by the purchaser subject to the agreed upon distribution in 7B. So you repay the loan first and then the profits are split. So if the vessel is purchased, the loan is repaid that way. The other side of the fulcrum is then in clause 5, in the event the vessel is not purchased, KJM shall return all funds. So if the vessel is purchased, the loan is repaid through clause 7B on a sale. If the vessel is not purchased, the loan is repayable immediately. That's clause 5. The only circumstance that the contract provides for in which the loan is not repaid is over the page 905, and it's clause 6B, and that is a default by Contessa. And that is a circumstance in which Your Honour finds that Contessa is obliged to advance funds and fails to do so in breach. Now, my learned friend said, well, the loan is an interest-free loan, but that's not the entirety of the story, because clause 6a, little 2, Contessa's remedies for default. In the event of a default by KGM and subsequent failure to cure, Contessa may elect to terminate the agreement, receive return of the loan monies, or any monies paid on the date of termination, plus interest at the maximum rate allowed by law. I've set this all out in my skeleton, but the way this arises is that in August 2024, when the transaction came to an end, clause 5 is triggered, so there's an obligation to repay. There is no repayment, therefore there is a default, therefore there is an obligation to pay interest. As I say, I've set it all out in my skeleton. But just so you want to understand the shape of this contract. So Joanna was posing a hypothetical to my learned friend about, well, what happens if an unsatisfactory report is presented? Well, the point about a condition precedent is that it's always open to KJM to have another go. So if they present a report and it's unsatisfactory, evidently what's contemplated by the contract is that they go back, worked on the boat, whatever, and then they come back. And then once a surveyor says this is satisfactory and Contessa agrees, the condition is triggered and the money is released and the purchase occurs. So there's nothing in the contract that prevents essentially the process that the parties were envisaging, which is that it gets surveyed and you have a report and you might need to go back and deal with things and then come back. The point is that what clause 2b is triggered by is that final bit in the process where the surveyor says, yeah, this is fine, and Contessa agrees. Just moving on, the next point by way of reply, to do with, and this is a very technical point, but the issue of whether there is, or Your Honour needs to decide whether there is a sale contract between KJM and Sino Eagle. I just want to make it absolutely clear. It has never been admitted by Contessa that there is a sale contract. So if Your Honour was taken briefly to the list of issues, at page 4, and my learned friend is quite right that the word draft ought to have been deleted. This is the agreed list of issues of common ground. But Your Honour will find nowhere in the common ground a statement that KJM entered into a contract with Sino Eagle, because that was never common ground. Where it comes in as an issue is down at page 7, where at 4.2, the issue was if Contessa was obliged to advance funds under clause 2b, 4.2, did KJM suffer a loss? Did KJM suffer a loss? And so the KJM has to prove its loss. And just to show you how this is put in my pleading at paragraph 55, sorry, it's the wrong page reference. Sorry, it's page 34. Paragraph 29. Paragraph 55 was the claim for the loss. Our case was, well, your loss is not admitted, save that we admit that the transaction between you and Sino Eagle came to an end. We didn't really say what that transaction was because we don't know. And then there's a plea about if the deposit is lost, that's not a loss suffered by you. So my learned friend has to make out a case in loss. So that's where that is. And my learned friend showed you a lot of correspondence, but where Sino Eagle asserted a right to forfeit the deposit, but nowhere the source of that. Your Honour made the comment to my learned friend when he was addressing the timing of the provision of the Admiral report about, well, what reason would they possibly have not to disclose it? I don't think Your Honour needs to come to a final conclusion on that question, but one can think of many reasons. The most obvious is what's quite clear from the correspondence, and I think Your Honour saw some of this in the cross-examination, is that at the very beginning, before the loan agreement is signed, everyone is sort of, certainly on the KJM side, talking about speed, and rather suggests that what was sold to Contessa was a boat that was ready to go. And it's quite plausible that when the survey report came back and showed some defects that needed rectifying, KJM took the view that they needed to go and rectify them and then come back. And of course, lots happen. The problem is that this transaction is conceived, and then a lot of other things happen in the parties' relationship, and it's clear that at various stages the Aquila just slightly gets lost.
I mean, you hold these dates in your mind. I don't. So we've got the report in July 2023.
Yeah, it's around the 10th of July. I don't think anyone knows when it is.
What date was the remedial document issued by the by the factory, by the yard?
That is the 29th of February 2024.
Okay.
That's page 1183, just for your note.
Thank you.
Just on waiver, I think my learned friend suggested that in my opening submissions, I had sort of conceded the pleading point. Absolutely did not. All I said was I can meet this case on the facts if necessary. But I made it perfectly clear, that's day 1, page 13. I made it perfectly clear that my submission was going to be this case is not open to him in closing. If Your Honour is against me on that point, I have things to say, obviously. But my primary position is none of that case was pleaded. And my learned friend asserted in his submissions that the full factual matrix is before you, but it's obviously not, partly because we didn't get an opportunity for any disclosure on it. So moving on to the JVA claim, I've just got 2 topics to cover very briefly. In terms of the late payments, my learned friend showed you a couple of documents which he asserted were demands for payment, but he did not engage with the prior question. And so if we go back to page 914 of the bundle, which is the second amendment, neither the second tranche nor the third tranche are payable on demand. So it is not the case that KJM or KJI can simply demand the second or third tranche. A demand is only relevant if there is a default and then a request to cure. But legally, KJM or KJI have to establish that some monies are due first before they're entitled to send a default notice. So my learned friend doesn't have a case on when these sums are due. So all questions of demands are irrelevant unless and until your Honour is satisfied that tranche 2 and tranche 3 were due on a particular date. And just because Mr. Al-Jasmi and Mr. Radwan assert that they were due doesn't make them due. Then in relation to the relief, it's the first time that there's really been any engagement with the relief sought on the JV claim. it has all been out there before, as I explained, but perhaps we could just go very briefly to the draft order, as if everyone's been looking at it. You want to raise the question of jurisdiction. There is no jurisdictional problem at all for this simple reason. None of the orders in this draft order are orders against the third defendant. They are orders against the first defendant, KJM, which is a party to the JVA, and the JVA has a jurisdiction clause expressly in favour of the DIFC courts. So all these orders require the first defendant to do is to procure various things. And it goes back to that passage in Chitty that I showed you, that where a party, KJM, agrees in a contract, here the JVA, to a certain result, it necessarily agrees to do all those things that are necessary to bring about that result. And that's why the order says procures various things. And so, again, my learned friend took you, for instance, to the provision of documents, but all those documents are documents to which my client would be entitled under Clause H, like, for instance, the bank statements of the third defendant. It's not accepted that it doesn't necessarily have bank accounts, like the bank statements to show where the money that's been paid into the joint venture have gone, obviously. And so the order is that if you want to look at it at page 43, the first defendant shall procure that the third defendant shall provide the claimant with the relevant documents. And that's because when you look at the JV agreement, for example, at 885, there is an obligation at HA on each venturer to keep books and records and to give the other venturer access to the other venturer's books and records. So that's about access to KJM's records. And then B, each venturer shall have unlimited access to the books and records. Well, what must that mean? That must mean that KJM must do everything that it can do in its power to procure that Mr. Ivankovich has access to the books and records. At the moment, they're all in the hands of Mr. Al-Jazmi, who is KJM's manager. Some objection was taken, if you could just go back to the draft order, to Baker Tilly. I mean, I had understood from the correspondence that there actually wasn't an objection to Baker Tilly per se. And one sees that at, well, I might just leave that there. I mean, I don't think Mr. Al-Jazmi has ever objected to the appointment of Baker Tilly per se. But there we go. I mean, the logic for enforcing it is if KJM agrees to a contract that says there will be an audit biannually, it's necessarily agreeing to do all things necessary to achieve that result. And that must mean, as the order provides, procuring that the General Assembly occur and voting in favour of the appointment of an auditor. So all these orders are entirely conventional orders for specific performance against the first defendant to require it to do all that's necessary to achieve the result that it agreed. But I leave it to you on. I set out a draft. If your Honour wants to deal with the mechanics of the draft at a second hearing, your Honour will have a view. But I think, unless there's anything else that I can assist your Honour with, those are my submissions.
No, thank you very much indeed. So there's nothing further, I think, for either party to add at this stage. We are finished with submissions, is that right? Nothing more from the claimant, nothing more from
nothing more from me.
In which case, it won't surprise you that I'm going to reserve my judgment, and I will hope to get it to you as soon as my workload permits. Thank you both for your helpful and interesting submissions. Thank you to the court reporter and the EP operator for their assistance. We couldn't function without them. And I wish everybody a good weekend. Thank you very much.
Thank you, Your Honour.
Thank you, Your Honour.